Welcome to day 2 of the Insolvency Law Training or Insolvency Conference. We welcome you back from day 1, where we had very amazing presentations, and we have a power-packed day 2. But before we do that, and before we head into what we have for you in day 2, is that we thought we could have a recap of what happened yesterday. I can give you comfort that our presenters are already in the room, and I have a privilege to take you through as a moderator for day 2. My name is Harold Tudije. I'm a liquidator and a partner at Sierra Manya Advocates and Solicitors. And as we did yesterday, we hope that we'll get an interactive class as and for the start, if you can hear me, I will need you to use your emoji of a thumbs up, regardless of the party that you subscribe to. And then we'll know that our class is set and very active to go for day 2. Now, yesterday we had a very, thank you, I can see the emojis. We had very deep presentations, and the first one was on the compliance challenges and recommendations in insolvency practice. And that was done by Mr. Ntale Mustafa, the Deputy Registrar General at URSB. And in that discussion, we talked about the common compliance failures observed among insolvency practitioners in Uganda, the legal regime of insolvency practice in Uganda. We talked about the practice challenges, specifically on how creditor interference and data non-cooperation impact successful insolvency administration. We talked about the genesis the insolvency journey has taken as far as legislation and regulations are concerned, especially in the office of the official receiver. We also talked about the continuing professional education and compliance standards at that. He also hinted on the recommendations as far as some of the laws and their amendments is concerned. We also talked about the lessons that we can borrow from other jurisdictions. Our second presentation was from the one and only Mr. Joshua Ogal, who's of course a partner at Legal Mark and also the head of Rekindle Capital. And he talked about the alternative approaches to distressed assets. Now, ladies and gentlemen, we are trying to break the barrier where every time we talk about insolvency practice, someone's mind immediately goes towards closing companies, and we forget about the alternatives for distressed assets. Now, he took us to, and we used the allegory of a life support, companies on life support or businesses on life support to make sure that their life stay up. He explored the innovative strategies, the legal and commercial considerations, and the practical implementation. I don't want to spoil Madame Kasule's mood, but at that point, that's where some blames as far as the regulator in Bank of Uganda came through as far as supporting financial institutions on some of these alternative ways to deal with distressed assets. We also talked about the practical applications and what factors should lenders and creditors consider before choosing an alternative restructuring strategy, and expanded it to, I think, the highlight of the day about the obsolete inventory, where lawyers had to question if they have the right number of lawyers in their law firms as an example of the signs that show that a business is running risk of distressed assets and getting out of business. And from there, we had our last presentation from Counsel Nelson Nerima on the effects of insolvency on corporate personality. And as we put it in yesterday's discussion, it was more of a very fascinating topic on the intersection of insolvency law and company law. Where do the shareholders come in? Where do the directors come in? What's the effect on other creditors? We had a very wonderful presentation on the case that was filed by URA against Crane on the rights of a taxman at the point of insolvency, the discussion on lifting the corporate veil and undoing fraudulent transactions at the point of insolvency. And he discussed the different modes on and the effect on corporate personality, specifically receivership, provision administration, and then liquidation. I remember we had personal questions and take home, and the first question was, does insolvency alter the company's separate legal personality, or does it merely change how the company is managed and controlled? And we asked another question, which was answered, that at what point, if any, does the doctrine of separation of corporate personality become less significant during insolvency proceedings? We also explored, finally, what is contained in an administration deed, who are the signatories, who is bound by an administration deed, to understand how company law at the point of insolvency meets the relevant statutes in that direction. If you are just joining us, I'm told we had one non-legal lawyer in the room yesterday. If you didn't understand anything that I've said, the answer is that it depends. You can take that to the bank, and at least you'll be ready for day 2. Now, for day 2, we have a power-packed day, and our first discussant or panelist will be telling us navigating the intersection of insolvency and taxation, and sharing more on the strategies for financial stability and compliance. And that is the one and only Tony Kalunji, who's already in the room. My active class can please activate the clapping emoji and make him feel welcome. And then thereafter, we'll have, as usual, our Q&A session after his presentation. Thank you very much. So what we did yesterday is that as soon as the question arises, you utilize your Q&A tab that is right on your screen after the share icon and shoot your question. We'll be sieving through them and sharing them with the presenter immediately after the presentation. And then thereafter, we'll have another presentation from Counsel Fred Muema on liquidation of financial institutions and sharing the interplay between insolvency law and Financial Institutions Act. That will be a preamble and leading us straight into our last activity of this two-day conference on the panel discussion, which will be specifically talking about the perspectives on liquidation of financial institutions. And on that panel, we shall have still Counsel Fred Muema, Justin Semiaba, and Madame Margaret Kagwaka Sule from the Bank of Uganda. The Ugandan joke that money will come, we already have money in the room. And then finally, that will be moderated by Andrew Munanura Kamtera. We are ready for day 2. The comfort is that for the conference, as we said yesterday, is that we are just talking about insolvency law and not experiencing it. So ladies and gentlemen, to set us off for day 2 is Mr. Tony Kalunji. Tony is not in a very good mood today because he works for URA and they almost hit the target, but they did not. And that means one side effect of that insolvency practice is that he might not get his bonus for hitting the target, but he gets comfort that he's lending his expertise to help us understand the technical aspects of insolvency as far as tax is concerned. Tony is a very hands-on man, and he has a very long CV, but I'll just give the abridged version. He's a technical tax expert and an officer at Uganda Revenue Authority. He's a tax specialist representing Uganda's Domestic Revenue Authority, focusing heavily on modern complex revenue mobilization challenges. He, of course, actively leads compliance strategy and represents URA in a high-level cross-border framework. Now, it's very important to note that Tony, in his official capacity, is the acting manager of tax appeals, and he's here in that capacity. Key expertise and what you should look out for is corporate tax compliancy, tax litigation, revenue law, cross-border physical structure, insolvent corporate tax liabilities, and public sector legal advisory. As a private practitioner who has met Tony on the other side of the table, I can testify and not concede that he's a thorough gentleman. Now, welcome, Tony. And as I gave the briefing, we will be talking about about the navigating the intersection of insolvency and taxation. And you will be sharing your expertise on the strategies for financial stability and compliance, because most of our companies, and even for the benefit of the class or the attendees of this conference, how the two interjoin. And I'm sure in your presentation, the question in every young practitioner of insolvency is that at the junction where tax meets a liquidator, who has the right of way? You're very welcome.
Thank you very much, Harold, for the introduction. Good morning, everyone. Yeah, I'm happy to be here. I had prepared some slides which I will use. I'm requesting that they be shared. But about the topic of the intersection between taxation and insolvency, tax is very unique and it intersects with other areas of law, even other disciplines. For instance, accounting. In accounting, you might determine your profits by basically getting the gross revenue and removing the maybe expenses, but for tax purposes, some expenses will be added back. So there will be a conflict between accountants and tax. And they argue, but I incurred this expense, but the taxman will say no, for the tax law you add it back. Company law, corporate and commercial, you'll have your definition of a company in the Companies Act, but realize that definition of a company will differ from that is in the tax laws. You'll come to have an interesting one of yesterday of medicine. You'll think something is medicine, yet the taxman will consider it as a food supplement. You'll argue and you say, oh, I now do poultry. Like, oh, I have birds. I've bought this thing to help me increase the number of eggs. And it will be prescribed by maybe national medical stores or pharmacy as a medicine, but for the purpose they will say no, this is a food supplement. So let me see. Yes, so I think we'll just dive straight in. I'll take it that you were building up on yesterday's presentation, the definition of insolvency, inability to pay debts. I'll go straight to the intersection and then we'll focus more time there. So the first one is what someone would consider a conflict of laws. The law for insolvency, the primary law will be the Insolvency Act. Now that law, if you look at it, you will have also other tax laws. Now the law that I picked, I was basically looking at the Insolvency Act and the Tax Procedures Code Act. Now under the Insolvency Act, that interesting priority section of Section 11 that says that the proceeds of insolvency, when they are being shared among its preferential creditors, the priority should go to the costs basically incurred of insolvency, employment costs, and then in there they list any tax withheld. Now that is under the Insolvency Act. But of emphasis is that clause 6 that says that section 11 shall apply notwithstanding any other law. So you can, from an insolvency practitioner's perspective, you'll presume that the Insolvency Act is supreme and takes precedence. Now, interestingly, Parliament also passed other laws that contain that clause. Now, from the taxman's perspective, we have what we call the Tax Procedures Code Act. Now, also it creates a priority. It will tell you that when it comes to withholding tax and value-added tax, it will tell you that this is tax that you hold in trust on behalf of government. It's not your money. Because the structure of VAT and WHT is that ordinarily this is not your money. The government is just putting an obligation on you to collect it and remit it. So because of that, you'll find Section 40 of the Tax Procedures Code Act telling you that when it comes to WHT and VAT, this is money that is a debt to government. You're holding it in trust on behalf of government. And for emphasis, to tell you that the government has a first charge on this money. Now, and it also concludes by saying, okay, for it begins by saying that notwithstanding any other enactment of Parliament. So the first intersectional, which I would call a conflict, would be which law should be supreme. Should the Insolvency Act apply notwithstanding any other enactment, or the Tax Procedures Code Act should apply notwithstanding any other enactment? Now that's where the conflicts begin to arise from. Now here, people take different perspectives. Now, but it also raises another interesting question. You realize that Section 11 of the Insolvency Act essentially puts withholding tax after. It puts it in a list and it puts it under preferential debts. Now, however, the same Insolvency Act has what we call secured creditors. But when defining secured creditors, it will tell you that a secured creditor is one who has a charge on movable property. So the question can arise that since Section 40 of the Tax Procedures Code Act says that the government has a charge on that debt, does that mean that now that withholding tax and VAT becomes a secured debt, and for it is secured and it takes precedence over Section 11 itself? That's a different question. Then also, the Insolvency Act will limit itself. It will talk about tax withheld without expressly mentioning VAT. The schools of thought in there are that the tax withheld means withholding tax only, but others say that even VAT is tax withheld. But even those who don't believe that VAT is tax withheld can find a conflict in that the Insolvency Act does not talk about VAT taking priority, but the Tax Procedures Code Act talks about it. Now, those are things that create intersections and disputes. We had one dispute of Bank of India versus NC Beverages and URA. Briefly, NC Beverages was a company, and in raising capital, it obtained debt from Bank of India, and a debenture was executed, creating fixed and floating charges over present and future assets of the company. Now, of course, that it also, in carrying out its business, they were making water, I think, but I think the company. So in that process, also taxes were payable, but they didn't pay the taxes. So on one hand, you had URA coming to claim the taxes that are owed, and it locked the premises. And we were served by an originating summons from Bank of India, from the receiver of Bank of India. And Bank of India was arguing that the moment the default on the loan happened, the floating charges became fixed, and then even the fixed became payable there and then. So the question before in that case was whether which takes priority, the fact that this was a secured creditor and the fact that URA's debts were preferential in that regard. But then also it brought out other questions of, because URA's, before even going into the merits of the case, normally what we do in URA, we challenge jurisdiction. So URA came from this perspective that this is a tax dispute. Should it be in the High Court, or it should be with the Tax Appeals Tribunal because of the Rabo decision that gives the original decision to TAT instead of High Court. It was an interesting case. Justice Mubiru's view was that there were many, he ended up saying that the Tax Procedures Code Act, emphasis on the word act, was a procedural law. Now URA's view was that, since it's already an act, isn't it also substantive law? But his view was that it's a procedural law. And true, because the Tax Procedures Code Act, when it came up in 2014, but what happened was that they got all procedures from the tax laws and put them in the Tax Procedures Code Act. So you have things under the Income Tax Act, VAT, stamp duty, that if you're not happy with an objection, you first object. They got all procedures and put them under one act. That was his, and by holding so, our objections on jurisdictions fell. So he ended up resolving the dispute that the bank took priority because its debts were secured. Of course, we put in an appeal, but without going into the merits, there are other questions that decision or these sections or that dispute raise. For instance, and I like to think of it this way, that the Insolvency Act came up in 2011, but it commenced in 2013. Now, the Tax Procedures Code Act was enacted by Parliament in 2014 after the Insolvency Act, and it commenced in 2016. So, if you go in resolving disputes, there are theories in common law of implied appeal. Because if it's the same Parliament that has enacted a law, the Insolvency Act, and has said that Section 11 will take priority, notwithstanding any other law, if it enacts another act later on, and it says notwithstanding any other enactment, you could reason, I like personal reason, that it ought to have been aware that there could be other enactments it made, but notwithstanding them, it follows that if you look at the doctrine of implied appeal, it means that indirectly the Insolvency Act was repealed. That is something you can consider. Then also general versus specific. Depending on the lens that you're using, it could be that which law is general in this regard or which law is specific. The insolvency practitioner will argue that since the company is in insolvency, the Insolvency Act is the specific law. But the taxman will argue that no, since there is tax in issue, and you're only focused on the tax, it follows that the tax law is the one that is specific. So, I don't know. So those are the issues. So there is a debate between the Insolvency Act and the Tax Procedures Code Act. And all those are issues. But then it also begs another question. If you look at withholding tax and value-added tax, and we agree that this is money held on trust, it's not, essentially not your money. You are a trustee. If for instance, if a trustee is undergoing insolvency, does the trust that is trusting form part of his estate under insolvency? You could argue no, and by doing so you may end up carving out withholding tax and VAT from insolvency proceedings, and you just remit that money before. That would make it even rank higher than the secured creditors. But all these issues are just thought. They have not been litigated. Disputes have not arisen. And when they arise, people normally focus on what has been said. But I hope in future, if opportunity arises, we'll question these things, because normally the liquidation processes that happen, people tend to overlook those questions, and they just make URA line up either as a preferential creditor. But I think if we push these arguments, we might either need consensus from decision makers or courts. So that is the first intersection. Now the other one is more of a repeat, but it's a bit different. It's under the Income Tax Act. It's the priority of withholding tax. Now, I'm also building up on from Section 11. Section 11 will tell you that any tax withheld is paid after you've paid the insolvency costs and employment costs. But now, we have the Income Tax Act. Section 145 will expressly say that withholding tax does not form part of the insolvency estate. That means when you're looking at your insolvency proceedings, first take away withholding tax. And then, but it says that the Commissioner General of URA shall have the first claim before any deduction. And those are specific words. Meaning, whereas there could be any deductions, the CG must have the first claim. And I think by bringing that out, does it mean that even the expenses of the insolvency are covered before any other deductions? Does it mean that when you're handling insolvency proceedings, first pay WHT under the Income Tax Act before you even get your costs? That's a question that arises. But still, also, you look at the Insolvency Act has that interesting provisions. Even when it allows for WHT to be, to form part of the preferential debts, it limits WHT to that incurred 12 months prior to the insolvency proceedings. Now, for tax purposes, that section 145 does not have a time limit. Meaning, if you have withholding tax that you have not remitted for all the periods, you should remit it. So another question comes in, does the time limit imposed under the Insolvency Act also carve out a time limit under the income tax that is silent? Those are areas I'm looking at that might form disputes in future, but I like to take a harmonized approach, not to say that a law conflicts with the other, but to put them together and we see. Because essentially, if you look at WHT, it's not your money. And briefly, I will emphasize it, how it arises. Before you pay for goods and services, if you're supposed to pay, let's say this conference, let's say to attend this training, you were supposed to pay, let's say, 200. If WHT was payable, it means you pay 200 less WHT, which can be 6%. So that means essentially, and you're supposed to remit that money monthly. So that is not your money. If there was no WHT, it would mean that you pay the 200 and ULS, while filing its return, pays it itself. But it's withholding in the name, it's not your money. So it begs, I wonder why when it comes to insolvency proceedings, you create a time limit of 12 months. What happens to that tax that was before 12 months? Are you going to say that it's taken? Then also, why would it even form part of the estate of the insolvency proceedings? When, first of all, it doesn't make sense, but the law, section 145, says otherwise. So there will be a debate between the Income Tax Act and the Insolvency Act in that regard. Then, of course, there are duties of insolvency practitioners under the Insolvency Act, but there are also duties of insolvency practitioners under tax laws. For instance, at the moment you're appointed a receiver, among your notifications under the Insolvency Act or the Companies Act, under the VAT Act, you're supposed to notify the Commissioner General within 14 days that, oh, I've been appointed and I've taken part of this number of skills to reason and make decisions in the best interest of the parties. But there's an obligation to notify, not notify him, but seek his permission under the VAT Act. And now also that it has also a priority claim. Now the VAT Act expressly, if you're to pay any other debts that are beyond VAT, you're supposed to seek permission. I haven't seen the practice around this, and the reason could be that maybe because of where there are things we normally don't focus on. Normally when you're appointed, you just notify, the thing will go to domestic taxes. They will not go in detail, but these are things that raise concern on how receivers have been practicing, because they are receivers, they handle the estate, but some notify, but I don't think they seek permission. And if you do, what if the permission is refused? What happens? Do you file a case in court? And must it be refused with reasonable basis? Because I don't think the Commissioner General will have tax, will have VAT that is payable, and he gives you permission to pay other debtors without paying the tax. If the Commissioner General did that, internally he will face audit queries and he will need to explain. So I'm thinking the permission will likely to be rejected, or if it's to be approved, it might be conditional. So that is a duty that is imposed. Now, there are also similar duties under the Stamp Duty Act, which you also notify, and before you part, you do that. Yeah. Then, whereas the company is under insolvency, income tax is still payable. Now, for income tax, it is split into three. There is employment income, business income, and property income. Now, if you're looking at Section 18 that provides for business income, it recognizes that during insolvency proceedings, business income might arise. And Section 18.3 will tell you that if you get any gain, even if you get any cancellation of a business debt, that's what they focus on, because it could be an insolvency proceeding and some people choose to forego or forfeit their debts. Now, if a cancellation of a business debt for tax purposes is a benefit, and since it's a benefit, the Income Tax Act treats it as if it's a benefit, but it refers you to a section of carry forward losses. Now, for carry forward losses, how do they arise? Essentially, tax is only imposed, income tax is only imposed on the profits that you make. However, it is possible for your allowable deductions or expenses to exceed the amount of money you've made, and you're in a loss. Now, when you're in a loss, you are allowed to carry forward those losses to the next year. Now, for insolvency purposes, if you're in insolvency, there's how this cancellation of business debt reduces your carry forward losses. Yes. Then we also have an interesting issue here of rollover reliefs. Rollover reliefs essentially are taxation terms. Without rollover reliefs, a typical transaction would be like this. If you transfer shares and you're given assets, you're supposed to pay tax on that transaction. But under rollover relief, if you're a shareholder if you're a majority shareholder in a company, and that company gives you shares and you give it an asset, it happens that you don't pay tax because your cost base is taken to mirror the cost base that was there before, so you don't pay any tax. So what most reorganizations or amalgamations or mergers do, they involve these rollover reliefs. They write to Commissioner General URA seeking tax not to be payable, and if you fulfill the requirements, you don't pay tax. But the Income Tax Act recognizes that there could be a rollover relief in a liquidation. What would this entail? It would entail that during a liquidation, the company under liquidation gives the majority shareholder, I don't know, instead you give them any property and they give you the shares. Now, from a tax perspective, that is okay, and it will have no problem. But if you bring in, and I think if you apply, rarely will the Commissioner General question these things. But if you look at the Insolvency Act and you go under avoidable transactions, you will realize that the Insolvency Act frowns upon insider dealings. So the question, insider dealings are those dealings between the company and its associates, shareholders, directors, borrowers, and so if those insider dealings happen 12 months, the presumption is that they are avoidable. It's not that the presumption is that they are good unless they are settled. The presumption is that they are avoidable unless you prove that they were carried out during ordinary course of business or there was nothing much. So this begs the question, assuming a company or companies going, or there is a rollover relief that happens 12 months prior to insolvency, will that mean that under Section 17, that transaction will be impugned for being an insider dealing? How will it be treated? So, because yesterday I followed through Council Nelson Nerima's presentation, I think someone posed the question of those insider dealings of shares being transferred prior or during insolvency, and his response was valid from an insolvency practitioner's perspective. From insolvency, you can take that transaction as if you're trying to hide assets from the creditors, and some of the arrangements will be rollover reliefs. You will tell the shareholders that, you know what, let us give you this land and you give us shares. So I don't know whether this is something liquidators will look at, but if you look at rollover reliefs vis-a-vis insider dealings, there's an intersection that needs to be looked at carefully. Then, of course, the common thing is the effect of insolvency on inventory or stock. Now, this is for taxpayers who deal either in manufacturing, distribution, retail, or they deal in any form of business where they have stock or goods. Now, there are taxes like VAT or local excise duty, where the mechanism of payment, where the final incidence of tax falls on the consumer. What does that mean? It means when a manufacturer is manufacturing their goods, they need raw materials. So the suppliers of raw materials will give them the raw materials, and those suppliers will charge VAT at, let's say, 18% or 0%. Now, when the manufacturer gets charged this VAT, when they make the good, and LED, when they make the good and they are giving it to the wholesaler, that transaction, they also charge the wholesaler VAT. So that the mechanism of VAT spreads through input and output. So at the end of the month, the manufacturer, whereas the person supplying the raw materials has charged them VAT, when that is their output, that is their input. When before filing the VAT, they get their output minus input, and normally you'll find that they won't pay any VAT, but the trail follows through to the final consumer. Now, when insolvency proceedings happen and you're a manufacturer, wholesaler, retailer, or distributor, and you have stock that you have not yet sold to the person next in the line, you're taken to be the consumer. So that inventory you have, it is taken at market price for you to be the consumer, and you're charged by VAT, and VAT arises. So while you're a liquidator or an insolvency practitioner, you should take note of this. Or even a company, before you try to go through proceedings of insolvency, you may need to decide whether it's better for you to first sell off that stock. Of course, vis-a-vis other business reasons. It could be that for you to sell, you will incur advertising costs, you will incur storage costs, you will incur transportation, you will incur insurance, you might need to maintain inventories, security. But if it makes business sense, you might sometimes need to sell. Or if you allow to go to file for insolvency, or if one of the creditors does so, they must be cognizant that immediately that is done, at the commencement, VAT and local excise duty will arise. And once they arise, those are taxes that are paid monthly, every 15th of the month, and they are on accrual basis. It doesn't matter whether they have paid you, you pay it. Now, as we saw earlier using other sections, this is money you hold in trust, and URA's view is that you're supposed to remit it, and doesn't even form part of the estate of insolvency. So it triggers that transaction, and you may find that as an insolvency practitioner, among the things you need to do is to first file some tax returns because of the commencement of insolvency. Yes, we also have treatment of overpayments. Yeah, now we used to have graduated tax. Now we are in a self-assessment system. So even if you had no tax liability and you went to URA today and gave them $1 billion, they will not refuse it. They will not say you have no tax liability, don't take it. So some companies pay taxes in advance. Why? First of all, because of the law. For income tax purposes, at the commencement of every financial year, you're supposed to file what we call provisional returns. If you're a company, that's twice a year. So you project and you say, this year I hope to make 100 million. You file a provisional return, but it triggers a tax due, and then you can pay it in advance. Other form of overpayments can happen when people who have withheld from you, or people who have charged you VAT, when they remit that money to URA, it goes onto your ledger and you have an overpayment. So there is an issue of overpayments and insolvency. And we have faced this. The classic case is that case of Sunfish Farm. I don't know whether the case was decided, but so Sunfish Farm was a company that on its own filed for voluntary winding up, of course with the argument that it will be able to pay, or it was unable. So it was filing because there were two arms of, I think later on they reconciled it into a proper way of saying that they were now able to, but there was a discrepancy between the pleadings. So when URA was brought on board, the taxpayer was saying that we have, among the liabilities we also have liabilities with URA. When URA ran their ledger, it came up that the taxpayer had overpayments. So of course the case was not decided since other parties agreed to it, but it begged the question of, you may not know that the taxpayer or your client you're dealing with has overpayments, because that case raised question of whether you can argue that you're not able to pay your debts, yet with URA you have overpaid tax. Why not use that overpaid tax, one, as a tax credit to settle the URA taxes, or even claim a refund and they give you cash, and that cash that you get, you use it to pay other debts or to reflect the correct position of how much debt you have. Because it would come off as if you have money in the bank, you've refused to pay, but you're claiming you don't have money. So now also, and then also it raises another interesting issue. The moment you file for insolvency, does that mean that the overpayments you have are supposed to be given to you and dealt with under Section 11 of the preferential debts, or URA must first remove its money? So those are issues that arise, but luckily enough, no one has tested them, but there are issues to consider. Yeah, and then also we have another intersection there, alternatives to insolvency. For instance, if your creditor or your major creditor is URA, must you quickly file for insolvency? Or do you have to procure other options that are within the tax laws? One, there are provisions that allow you to request for waivers, whereby you say, this tax, I request that it is waived. For instance, are you aware currently there is the Income Tax Act was passed by Parliament, but is yet to be assented to. But what was assented to that is yet to be gazetted is the Tax Procedure Code Act. And in there is Section 47. Now 47 will tell you that all tax areas that precede 2016 are waived. So now there is a question, or it will tell you that interest and penalty can be waived if you pay the principal. So you can request for waivers. Then there are remissions where they forgive you the tax. Then there's where for taxes like VAT, instead of you paying the VAT, the law can deem it that you have paid it. Then there are things like installment payments. Instead of you going opening up the basket of insolvency, why not just see if you can pay that tax in installments? Then there are voluntary disclosures. You can say that you've examined the affairs of the company. There are some tax irregularities, but you request to pay the principal, and the interest and penalty can be waived. Then there are debt write-offs, there is compounding. You can be incurring a lot of losses, then you can also carry them forward. So the tax law has alternatives to insolvency that can be looked into. Yeah. Then, of course, the other one is jurisdiction in case a dispute involves both tax and insolvency. Yes, proceedings of insolvency can be going on, but normally the taxman will think that since it's a tax dispute, they will want to put shoe to the tax appeals tribunal, or you might be comfortable with the high court. Because the moment you go to the tax appeals tribunal, there are other preliminaries like paying 30%, the dispute is streamlined, and then they might only consider tax. So there is that debate on jurisdiction that is covered in those cases. In NC beverages, Justice Mobile held that it has to be the High Court with unlimited original jurisdiction, since the matter contained both. Yeah. Yes, now this is, we have gone to topics that are interesting. Now there's insolvency as tax avoidance. I attended a training on anti-money laundering and corruption, and one of the studies showed that certain people were engaging in corruption or money laundering because of the sensitization that had been created by agencies that were there to curb corruption or anti-money laundering. And the story was told that normally when people come to teach you about corruption or anti-money laundering, they will tell you that this person got 32 billion, this person has a wonderful house, this person has, the kids are studying, I don't know from where, or they have a beach house. Now in there, the person teaching you, sensitizing you, is thinking you will frown upon corruption. But some humans look at it and they're like, wait a minute, this person has this car, has this. So some people might be swayed by sensitization to do the bad thing, yet if you stop at it and don't sensitize, they might do less. So I may not go into detail into the tax avoidance schemes, but if you really sit down and you look at insolvency, there are a lot of ways it can be used as a tax avoidance scheme. Some people, instead of paying their taxes, can choose to file for insolvency. How do they? And they make sure before filing for insolvency, they'll, for instance, look at those sections that are like, I'll still have to pay taxes, but the tax payable will be that tax that has arisen 12 months prior to the insolvency proceedings. So let me first wait and I make sure that tax falls 12 months before. Then they go and they are like, okay, assuming they are to lift the veil and pull assets of associated companies, what's the definition of companies that are associated? Then they will arrange the structure. There are companies we dealt with whereby before a company or before a company files for insolvency, the first thing they do is go to the company URSB, the company registry, and they make a change of shareholding. And that change happens like 3 years back. So you find there are new people who have filed for insolvency, yet if you see through or trace, you might think there are other things. So that one, but there are structures within insolvency that you can use that really can be taken to be as tax avoidance. And then also to emphasize the point, among the eye openers of tax, when they are trying to teach about tax avoidance, and it is true, they tend to differentiate tax avoidance from tax abuse. And they will tell you that tax avoidance is legal, but it is tax abuse that is illegal. Now, that is true, but deeply, the more you do tax, you realize that whereas it is true that tax abuse is illegal and tax avoidance is not illegal, but even tax avoidance has consequences. From an international tax perspective, you're not entitled to benefits under a domestic tax treaty if you are involved in tax avoidance, not abuse. So if you carry out tax avoidance, you might lose benefits of a treaty. Then also domestically, URA has powers when there is tax avoidance to rearrange a transaction. So you will carry out your transaction and you say, normally it happens between associates, and you say, this associated company just sold its land. Normally, let me use a quick example, since now we have people from banking, maybe one that covers both. For instance, it could be normal in business for a company to sell its assets, and then after selling both its assets, it gets leases, or it sells its intangibles and it gets licenses. You could be a company and you own this land and you sell it to another company you've incorporated. And then after you tell that company, give me a lease of 99 years. So you find that that company has given you cash that is able to fund your activities. Or if you're dealing in intangibles, you sell your intellectual property to a company, and then it licenses you. Normally, these international companies are the ones to do it. If you look at Coca-Cola, you'll find that it merged with Renzori. Now it's called Renzori, but now there is a company called Allied Beverages. But then there is Cadbury Schweppes that own the trade. You'll find it's something like this. Now, for tax purposes, that transaction or those transactions, what we do, the basics ones I've talked about. For instance, we'll take it, whereas you have sold land and the intangibles, and they have given you a lease or license, we take it as if it's a loan. Because essentially, you needed money, but instead of the company loaning it to you at interest, you thought it best that you sell, and then they give you a license. So that instead of you paying it interest, you're now paying it rent or under a license, whereby if you go under the different taxes, you realize that rent is a claimable. So because of that tax avoidance, URA rearranges the transaction. You're like, no, you sold land, true, but we are taking it as if that was a loan. Now, those are the consequences of tax avoidance. And tax avoidance is, in my view, of a greater burden than tax abuse, because for tax avoidance, it need not be intentional. It could be a consequence. For instance, if you enter into a transaction whereby even if your intention was genuine, but one of the primary purposes or result of it was to give you a tax benefit that the law didn't intend or foresee, the transaction can be rearranged. But in insolvency, that can be done. You might undergo insolvency and you're like, oh, let us try to give this person this and this, but it can be rearranged. That, if to find out more, you can read Crane Autos and see. Oh, then also there is lifting the veil and pooling assets. We tried that and were successful. Mr. Nelson Nerma yesterday talked about And I agree how the definition of associated companies under the Insolvency Act is lean, but it was broadened in Crane Autos, yes. But interestingly, while doing research, we relied on some of the cases that had been done before. There's a case of Rift Valley, I think, in liquidation, where Justice Sekan had taken a broad view. Yeah. But then also, if you look at the definition, whereas it is specific, if you go to that section 1 of the Insolvency Act, it says that in this act, unless the context otherwise requires, it lists the definition. So our view was that, fine, if you go down there, associated companies have to be those where the company liquidation has majority stake. We were capitalizing on the context requiring otherwise. Then there is bad faith. Now that case of capital venture, there was a taxpayer just had a dispute, the debt was there, they just filed for insolvency, just so. Then inability to pay debts, there's that case of Fravold, where they were without a statutory demand, or even any proof someone filed that they should be allowed to wind up, and it addresses what you need to prove for tax purposes. Then the last one would be, I hope it's the last one, tax enforcement during insolvency. Now this is the issue that causes dispute. When we tried to go and enforce, and normally insolvency practitioners, I don't know why, they fail to recover the debts. The debt is there for years, we are not aware. Then when we go with our enforcement, with our security, then they wave a paper, we are like, but why don't you put your security? Like, we can't manage. But this raises issues. One, URA, before going to enforce a property, has powers. First, charges that property that is movable. Now, when you're defining secured creditors under the Insolvency Act, they tell you secured creditor is one who has a charge over property. So before enforcing, we have charged, and we believe we have become secured. But the insolvency practitioner comes with the Insolvency Act and puts us under Section 11, that now for you are preferential. Now, because of the mix-up, normally we settle these matters, but those are issues we haven't litigated upon. But from the taxman's perspective, we would, I don't know, you can look at it and think whether we are secured creditors or not. Yes, and whether we should do the pari passu with other people, we should wait. Yeah. So basically that is it. Now, essentially, because of time, I will summarize. There are obligations you have during insolvency, and there are those you will have probably before. During insolvency, you must make sure that you continue complying with other tax laws. For instance, Section 11 of the Insolvency Act will tell you that, first of all, you take care of your costs first. But I think the next block under clause 11.4 will be the payee. So if you're paying the employees of the company, our view is that pay as you earn arises, and don't wait to push us under. The moment you pay, the wages also give us the payee, even if it's not listed, because it's the harmonious interpretation of both laws. It can't be that someone under insolvency does not pay as you earn, and no, you have to pay. VAT, if you sell these assets while you're liquidating, pay them. The duty to maintain books of account still arises under the Tax Procedures Code Act. Don't throw them out and say the company was under receivership, the books got lost. No, maintain the books of account. Yes. So, and then also, but what we normally encourage is engagements. Engage URA, and then they see how they can tell you what the problem is or the issue is. Or you would be shocked that some people still have overpayments. For instance, yesterday there is a case that was discussed, or was it Crane Autos in liquidation? Yeah, yes, you find yes, but that one is one. You find that some of the associated companies had overpayments, which we are used to settle. Then also you'll find financial institutions, for instance, Crane Bank, before it went into that dispute, those insolvency disputes, it was previously awarded as among the best tax compliant payers. So you would be shocked that, for instance, it had overpayments, which you might need to use to settle liabilities. Then also, basically, before engage. So, but then also comply with other laws. So I'll finish off maybe with the recommendations to the liquidators to, while you're carrying out your documentation or your file, make sure you have all the information that is needed make for tax purposes, so that when they come and they ask for information, you're able to provide it because you have taken over the company. Don't wait for URA to assess. If there's any tax payable, you write a letter saying that you believe the tax payable is this. Then also know what URA needs, keep the evidence there, communicate properly, and then seek directions. There are some taxpayers who have sought direction. Yesterday I saw there was a colleague from Legal Mark, I think when they were handling Uganda Telecom, now I think it has changed name, but by then the Uganda Telecom, UTL, they were able to file an application before the High Court seeking guidance among other creditors. There was whether they should go ahead and pay the tax, yet the amount is limited, yet so you can seek directions from court, even from URA itself. And then also you might need, I've seen most insolvency proceedings that are successful involve those who engage with URA, because of URA has the benefit of enforcement. We may go to taxpayers that you may not go to. For instance, you go to taxpayers, either they are deep to reach, or they are powerful, or they are hostile, but URA has that protection whereby it can come under the Tax Procedures Code Act. If you allow, it recovers, sells the property, takes its tax, and hands over the rest to you as the liquidator, instead of you fighting it and fighting both, and then it does. Although we have also seen what we call what would come off as connivance, whereby, especially for taxpayers who have liabilities with banks, for some reason they prefer to maintain a good working relationship with the banks instead of URA. So you find that someone gets loans, does not pay the loan and the taxes, but then when URA comes to collect the taxes, talks to the bank, or is the one who even informs the bank to be the one to file proceedings in court to recover. And when you look at their evidence, even if they are party to a suit, they are not neutral. They are just agreeing to the loan. The loan is there, the interest is there. But when it comes to tax, they are like, the taxes are low. So you find as if URA is lonely in court, yet we are also debtors. So basically that is it. Thank you so much for sending to me. Over to you, Harold.
Yeah, thank you very much. I am waiting on my active class to show me the clapping emojis. Even when you do not subscribe to the ruling government, I know they are yellow, but please clap and make appreciation of a wonderful presentation from Tony Kalunji from the Uganda Revenue Authority. Very insightful. I know you hinted on tax avoidance. I want to tell you the truth that one thing the taxman and the taxpayer will never agree is what amounts to tax planning and tax avoidance. We can have that debate all day, but very wonderful presentation. Thank you for making the time. We had agreed at the beginning of the presentation that we will have questions drop in the chat and also on the Q&A icon on your screen. There's one that had come in, but it was deleted. I will assume that one picked understanding amidst the presentation. If it was deleted in fear that when you ask a question, they will check your tax compliance, I would want to debunk that theory. Please feel free to ask your questions and keep them flowing. But one of the questions that I wanted further explanation from our presenter on is regarding, and we'll have a self-assessment as usual, but let's talk about the responsibilities, especially for the insolvency practitioners on the call. Who bears the responsibility of ensuring tax returns and statutory filings made during administration or liquidation? I think it's one of the things that needs to come out clearly for the insolvency practitioners on the call. And then while dealing with that, yesterday we proceeded to discuss on the topic of business rescue. Now, also one of the things that came through is the barriers that are met for tax, the creditors who are financial institutions, but also as URA. So how is URA dealing with when an insolvency practitioner pursues business rescue? Are you seen as an obstacle, or there is leeway to negotiate and be part of that making, that instead of killing the child, we can amputate and see how we can survive and give life to the business that was about to collapse? As we wait on more questions and prepare for the self-assessment, let's have the answers to those two questions.
Okay, thank you so much, Harold. So about who bears responsibility for returns during administration or liquidation. Now, the way the tax law is designed, the obligation was put on the taxpayer itself. The tax law did not treat the taxpayer as a see-through or transparent. To go deeper, to state that this and this one should file. However, what it did, it put up a responsibility on who is to bear the burden or the penalty in the event there is failure to file a return. Now, failure to file a return is an offense under the Tax Procedures Code Act. Now, the Tax Procedures Code Act provides that the director or a principal person of the company is liable for any offenses committed by the company. So I'm thinking if a return is not filed, the first person to look at, if we had to split the taxpayer, who is the company, would be the director. But that director will have a reason to say that the moment administration or liquidation came up, I ceded most or some of my powers to the liquidator. And it would follow that the liquidator will assume the principality of the business, and the liquidator will be the one to file. In what I've seen practically, the liquidator is the one who engages, because they are given the TIN and the password. So the responsibility under that analogy to me would normally rest with the insolvency practitioner, whether in administration or liquidation, unless while dealing with the director, they allow that director to take responsibility. But then also practically what happens is that some entities tend to outsource. We have what we call tax agents or representatives, whereby companies, because of their structures and so much, you wouldn't expect the real director of, just an example, of BOI or any bank to file. No, they will normally outsource it to a person who would, either a lawyer, an accountant, or an auditor, or even someone in-house. So normally it will be that agent who then will take responsibility to file the return. Yeah, so that is it. About business rescue, I did some think there's a colleague at UCC. I don't know, I forget his name. He wrote an interesting book on business rescue. Then I also did some research about it. The legal framework on business rescue is not clear, or even if it's there, it does not properly address tax concerns. From what I understand with business rescue, URA will not, it's not properly engraved in the law. They might try to look at someone who goes direct into liquidation and receivership, but if you take that thing of business rescue and you try, normally you just have to engage with URA on an understanding. Now, depending on how you manage yourself and the blessings you have, that is when you can try to reason with them. But normally it is welcome. And URA has a history of also engaging in business rescue. Sometime back, there was a broadcast, a TV called WBS. I think we gave instructions to Mr. Karamaj of Legomark by then to take over what URA viewed as a business rescue. Of course, then there are other entities. There are those buses, I don't know, Pioneer. There are trials we have had. But normally when you come to URA and you want business rescue, it will normally use its own provisions of the law to make you procure those. For instance, it will tell you to ask for installment payments, or it will tell you to ask for waivers, or it will try to see if some interest and penalty can be waived. But normally it is welcome. But just like the challenge is that just like everyone finds it challenging to pay taxes, you find that each and every taxpayer, even those who you look at their bank accounts or financial statements, will try to argue that they don't have money when it comes to taxes, that they need help, that that money you see on the bank account is just operational income, that that dividend that was declared. So there's that ambit, but normally business rescue is welcome. Just that the legal framework within which to do it, to look at the procedure or forums or what to do, is what URA does not have, and we just have to use a mechanism that is available to us to see that you fall into play. But people have negotiated. There's a debt write-off arrangement whereby if you fail to pay, you can try to engage URA and they write off your debt. Yes. Okay. Thank you.
Thank you very much. There's a question which we'll also need you to explain. The background of it is the intersection between Section 76 of the Income Tax Act, which I believe is on rollover relief, and then also Section 17 of the Insolvency Act that is on insider dealings. It's one of the things that you touched on. And one of the people on the call asked, how should Section 76, which we talked about, that is on rollover reliefs, of the Income Tax Act be interpreted where assets vest in or are transferred by a liquidator under Section 17 of the Insolvency Act? And the further question related to that is, does the statutory vesting itself constitute disposal capable of triggering capital gains tax before any sale to a third party? So let's first start with the first one on rollovers and insider dealings.
Well, I'm going to answer, but I'm going to first put a disclaimer. Because of the practice, if that question you have is going to be a transaction, the best course of action would be for you to apply to URA for guidance or a private ruling, so that you get something binding. But still, here, since we are amongst colleagues, I'm going to give my understanding, me, as Stone, which might be different from what you might receive from URA, or which might even change if at all it becomes a dispute and then you find me arguing the other way around. My understanding of 76 is that how should it be interpreted? My interpretation is that there will be no tax. The final result will be that there will be no capital gains tax payable, because the cost base of the asset in the hands of the liquidator or the company in liquidation would be taken to be equal to the cost base that is immediately acquired after the asset is transferred, and it falls squarely under clause 4 under rollover relief. So there will be no tax payable if you tick all the requirements. If you don't, then there will be tax payable. But the requirements are that you must make sure prior to the transfer that shareholder owns majority, that is 50% or more of the company. Yes. Now, if you bring in within the context of section 15 and we go to insider dealings, it creates issues that probably need to be debated. One of them, in my view, if the transaction is voidable, it follows that even the benefit you had, of course, that's when we go into voidable and illegality. And we go into those cases of Kulubia. You know how they have disturbed people in different areas, where if there's an illegal transaction, does it mean that everyone loses? Or does it mean that we go back to a position where no one loses? So that is basically it. But my thinking is that if it's voidable, and it's indeed voidable, then it follows that also the other transaction will be reversed. And once it is reversed, then if that asset that is sold goes back to the company liquidation, and then also those shares that you're given are also taken back. So you go back to where you were prior to the transaction. Now, does the statutory vesting itself constitute disposal? There is an exception when it comes to capital gains tax. Capital gains tax is there if there is a disposal. But if the disposal is involuntary, then you get a ray of hope. However, the full ray of hope is that it is couched in a way that if it's involuntary, you must make sure you reinvest the proceeds of that disposal in an asset that is similar in nature to that one that has been disposed. So this, in my view, I think since it is triggered by statute, I would argue that it is involuntary. Just like that old case we had of Bank of India, there's when Bank of Uganda increased the minimum amount of shares and that companies dealing in banking had to have before they were regarded to fall under those specific tiers. So companies were forced to increase their shareholding to meet up with the statutory requirement. And I think it was Bank of India by then, URA tried to argue that that increase created a gain, but it successfully argued that since it was not voluntary, there could not be a gain. But after that section, of course, the law was amended. But I will argue that since it's not voluntary, then it follows that there shouldn't be any capital gains. However, you might meet resistance where they require you to show that the proceeds of that disposal have been reinvested in an asset of a similar nature. For instance, whereas something is not voluntary, how do I call it? Let's say, let me give the typical example. Now it's not UNRA. Ministry of Works is going to acquire land forcefully, and when they give you the money, you find that the value before and the value after they gave you was a lot. You can argue that it was involuntary. But the tests that we have been applying have been that you must go and at least use that money to buy land, if they therefore to escape. But if you use that money and you go and you probably change your life, as the saying goes, without reinvesting, then you might fall outside the test. So, I know that's the response to you, but again, it might depend on some fact can trigger this question because it's an analysis of the facts, but that will be my stretch or understanding and response to the question.
Okay. Finally, we have a question from Samuel Akwarema, also on the call, and he asks that you mentioned a number of instances of incoherence of legislations, and of course we pick different examples from the Tax Procedure Code Act, income tax, if they are viewed in light or vis-a-vis the Insolvency Act. And he asks that, are there plans to address these incoherencies in conjunction with the first Parliamentary Council during the next possible revision of tax-related legislations, rather than wait for the incoherencies to be tested during implementation or through litigation? And his comment is that surely the legislative process should provide better coherence on various legislations. Maybe a comment on that?
So I don't know. I think it's a valid question. There are two schools of thought. There's what we call the harmonious rule of statutory interpretation, where you recognize that different statutes, for different purposes, are allowed to have different provisions regarding the same subject matter. And it's only in dispute resolution that you can try to interpret them without causing a conflict with one another. So that would entail that would mean that it's okay. Insolvency practitioners can continue, the taxman can continue, and one day when they meet, they can sort it out. Because the law can never be in sync. There will always be those minimum things that look different. But then also the general view would be to, I guess, try to reconcile these laws. But then also it is a view, because the process of amendment, and I think for this one it might be Uganda Law Reform Commission, to do research. It could be that my view is wrong. Some people look at things and they're like, no, there is no conflict, or it is. But if indeed the conflict exists, then I think it would be best to try to reconcile the laws. But then also there will be a challenge because there are stakeholders. The Insolvency Act stakeholders, in my view, research shows that majority of the creditors under the Insolvency Act are under the banking finance industry. Now, also those under the tax laws, it's the taxman. And the two will never meet because this is someone who has failed to pay debts. So the country might need to decide, do we first take to the coffers in form of tax, or do we first give the investors back their share so that they continue to invest, so that the country continues to attract investment, or so that it has ripple effects of other industry? Now that conflict tends to be tricky and people tend to leave it. But true, we might need to reconcile. But my view, I think the reconciliation, if you look at it in form of public policy, my view is that I think let taxes first go. Because if taxes go, it's essentially not, it's your money, it's everyone's money. But if you first take other creditors, it could be argued that they are private, that the benefits might be limited to the private investors. But if the money is taken and constructs a road or hospital, even other creditors will use that road. But if it's taken and goes to dividends and interest, we might not really feel the impact of it all. So I would prefer that if there's any reconciliation, if any, it should be the taxman to take. But if it's to be to other creditors, it's best we leave it as it is, and then we litigate. And every judge, depending on the facts of the case, can take, and for valid reasons. Because even URA, it can't be that you have a taxpayer, the taxpayer has been transacting for 12 years, you're not collecting the tax, and then you wait when they are in insolvency and you say, give me all the money. No. There, even you, they should question you and they say, where have you been? But then also a banker, if you have a loan and you've been re-engineering it, extending it, it can't be that now that they want to pay taxes that you come and you say, I've been a creditor, but there's evidence of you extending the loan, foregoing interest, or if you look at it in strict sense, the amount of money you lent out as principal and vis-a-vis the total amount of principal and interest. Let's say you lent 100 million and over the course of years you've collected 900, but you still demand another 1 billion because of defaults. I don't know, in fairness it should be that really you lent 100, you've collected, stop there. So things like that are what keeps us interesting. So that will be my view. Harmonization is welcome, but it's best that the determining test is public policy versus private benefit. Thank you.
Thank you very much, Tony. I will ensure that Uganda Law Society gets that last bit and sends it to the CG and HR for your next appraisal. Thank you very much for the presentation. It's been a wonderful time. And for the benefit of the class, don't worry. I know we are almost at the point where coffee takes a priority over the unsecured creditors, but we can still have our self-assessment and then have a 5-minute health break to allow our next speaker on the panel to set up to proceed. Now, from the presentation, you should be able to answer the following in your heart of hearts. 1, how should insolvency practitioners balance the interests of the tax authority with those of other creditors? And 2, should tax authorities enjoy any preferential treatment in insolvency proceedings, or should they rank equally with other unsecured creditors? And 3, what tax compliance obligations continue after insolvency proceedings commence? 4, who bears the responsibility of ensuring tax returns and statutory filings to make sure that they are made during administration or liquidation? 5, which is the second last, what are the consequences of failing to maintain tax compliance during insolvency? And finally, about overpayments, what are the rights of a liquidator or insolvency practitioner on assuming instructions where there are issues of overpayment by a company undergoing insolvency? That, ladies and gentlemen, brings us to the end of the first segment of our day 2. Would like to appreciate Tony. Thank you very much for making the time, for lending us your wisdom and expertise on this area. We pray that you continue to flourish in your calling and vocation. Yes, so ladies and gentlemen, I would like to also recognize people who walked in the room during the presentation. Thank you very much. Very active class. You can clap again and show that you are listening attentively. Yes, we had, of course, from the beginning, we've had Madam Margaret Kagwa Kasule, who's already in the room as one of our panelists, who was also joined by Councillor Justin Semuyava. You're very welcome, Council. Thank you for gracing us with your presence. And also the moderator for the panel, Councillor Andrew Munanura, is also in the house. We welcome you, Council, and glad to have you today. So it's actually 16 minutes, we can say 15 to 11. We reconvene at 10 to 11 to start our second discussion on liquidation of financial institutions, discussing the interplay between Insolvency Law and Financial Institutions Act.
shaping up here. And I'm also very honored to come here and share with my colleagues on a subject that is very dear to me, the subject of banking is one of those practice areas that I enjoy most. I was given a big task of presenting a paper. I only learned that it had to be a paper a few days, I think yesterday. I thought we were just going to have a panel discussion, but then I was told I must write a paper. So I have not had sleep for a long time just to get this out. My topic is liquidation of financial institutions, the interplay between insolvency law and the Financial Institutions Act. I hope the online audience can hear and see us. So I was telling the moderator here, that the MC, that I'm not used to reading speeches. I like to talk off cuff, but now I have a prepared paper which I will take you through, and hopefully within the given time we should be able to close this. Not to forget to appreciate you for being able to wait for us to put this together. So my paper has 8 parts. It will have an introduction. Then I will also have, because my opinion is that we don't have an interplay between the Insolvency law and the Financial Institutions Act when it comes to liquidation of banks. So the second part will be, I will talk about the separateness, understanding the separateness of liquidation under Insolvency Act and the fear. And of course, I need to recognize the panelists, my senior colleague, Mr. Semiyaba, our boss here from the Central Bank, board secretary, and you're no longer board secretary, director legal. I'm sorry if I get it wrong. And then I'll also be dealing with the evolution of the liquidation regulatory framework. You need to have a background of how we have come to this point in regulating of dealing with the liquidation of banks. One of the key highlights, not a very good one, is the parliamentary report on the closed banks. And then I'll also go through the 2 models of liquidation of banks, the voluntary and the one commenced by the central bank. And then I'll also talk about the issue of abuse of liquidation powers, which Parliament cited against the central bank, and then have a conclusion. So the financial institutions, like other businesses, definitely face challenges and failure. The only difference is that the failure by a bank is a matter of national concern, and this is because it can precipitate an economic implosion. Sometimes it has led to recessions, like the recessions in the US. Most of them are linked to failure of banks, and this has got a lot of consequences, disrupting credit flow, basically because of the vital role that financial institutions play in the monetary sector. They are so fundamental that their liquidation must be handled as a special case. This reason for handling them separately, I have borrowed from the European Parliament, the reason they gave in 2014 when they were passing some regulation 806. They said that liquidation of a failing entity under normal insolvency proceedings could jeopardize financial stability, interrupt the provision of essential services, and affect protection of depositors. The objective of resolution should therefore be to ensure continuity of essential financial services, to maintain stability of the financial system, and reduce the moral hazard of minimizing reliance on public support for failing entities. So this is a public good. Okay, these banks are public goods, and anything that affects them will affect the whole ecosystem. So what have we learned from trying to deal with the global financial fragility? Because it has always been up and down for over 300 years, since the first banking crisis that was in the Netherlands more than 300 years ago. What we have learned is that any handling of liquidation of banks in the normal way, the way you handle a transport company or a food company, will lead to serious systemic risks, including financial contagion, and this is likely to crash the economy and erode public trust. Banking is so sensitive that a small thing, a small whiff, will get a run-in on the banks, and that affects all of us. So we have learned that the two must be different. Therefore, requiring me to interrogate an interplay between the Insolvency Law and the Financial Institutions Act in the liquidation of financial institutions in this paper is very wide. It goes beyond a legal discussion. I should state from the onset that there is no interplay or reciprocal relationship between the two legislations on this subject. As I shall explain in the subsequent pages of this paper, the key legal dynamics and procedural intricacies in liquidating financial institutions sit on different tectonic plates. So we need to understand why are they different, why are they separate, and immediately you will see this in the main purpose for enacting the Insolvency Act, which, as you know, repealed the Bankruptcy Act and the Deeds of Arrangement Act, Cap 75, which I'll refer to later. But the Insolvency Act provides for receiverships, administration, liquidation, arrangements for situations of bankruptcy, and it is true that it actually also deals with insolvency and liquidation. In my analysis, I have noted that it does not immediately define its scope. However, when you go to Part 3, you'll see that there is the insolvency procedure there for individuals. And then in Part 4, you'll see the insolvency procedure for the companies or the corporate entities. I think this is what influenced the title that was given, the presupposition that maybe Insolvency Act has something to do with banks. I take the view that despite providing for corporate insolvency procedure generally, the Insolvency Act does not apply to financial institutions. And I need to give a small background on to support that view. We used to have the liquidation of financial institutions being governed by the Deeds of Arrangement Act, an old 1931 act. At that time, banks were treated like other ordinary corporate entities. This treatment continued even after the enactment of the Banking Act in 1955 and the Banking Act number 16 of 1969. We didn't have the special framework on liquidation like we have under the FIA. What's interesting is that our first bank in the country, the National Bank of India, was established in 1906 under the Financial Institutions and under the Financial Institutions Act 1993. my observation is that from 1906 to 1993, we had 18 banks in Uganda, but none of those banks were ever liquidated. And during that time, we had more than 10 major banking crises in the world, in the US, in Europe, the Asian bank crisis. But for us here in Uganda, we were not touched, maybe because most of us are unbanked and we are out of the, the global money market, I don't know, but we're untouched. And my question is, it's not clear whether the problem was the bankers then, between 1906 and 93, were sharper than the bankers who came after 93, I don't know, or were the regulators who were sitting in Madame Kasule's chair less stringent, less strict. So that is the background of how banks were, liquidation was governed before 1993. Now, the Financial Institutions Act is a special banking legislation. It comes into force in 93, and in its long title, it's intended to regulate, control, and discipline financial institutions. So you can see straight away that it displaces any claims to controlling, disciplining, or dealing with banks. And it's very clear in Section 1 that it applies to financial institutions. So this takes financial institutions outside the ambit of corporate insolvency under the Insolvency Act. So in other words, the FIA is a lex specialis, a specialized statute governing financial institutions. If you look at it, you'll see that in Section 98(3)(b) and 105(2)(b), it expressly forbids application of the preferential ranking claims. How you rank claims under the Insolvency Act does not work under the FIA. They have their own system. So whereas both the Insolvency Act and FIA deal with liquidation of corporate entities, under the lex specialis doctrine, also referred to as generalia specialis, special bas non derogant, where two laws govern the same factual situation, a law governing the specific subject overrides the law governing only general matters. So the FIA overrides the Insolvency Act when it comes to liquidation of banks. Moreover, the FIA, which is a latter statute, prescribes the same mechanisms of receivership, liquidation, administration, which are found in the Insolvency Act. And you will see an elaborate procedure there on how banks are placed under that process of supervision, receivership, or liquidation in parts 8 to 11 of the FIA. So in light of the foregoing, the special legal regime established under the FIA operates independently of the general regime under the insolvency law. So there is no interplay of the two legislation. So ideally, I'm supposed to stop there because the topic you gave me has hit a wall. But I found a way forward. So having said all that, I do not intend to lose the topic for discussion. I will instead iterate this paper to an interrogation of the legal regime governing liquidation vis-a-vis its implementation. So my main focus is, let me look at the law and see how it has been implemented. In there, I hope that I should be able to obtain a commentary on the liquidation of the 8 banks, which has happened from 93 to 2024. Through this improvisation, I hope to weave a related story similar to the topic that you had given me. So that's what I've done. And I will start on that improvisation by giving you a background. This is very important to give context to the subject at hand. You will see there that from before 1906, our great parents didn't know about banking, because the first bank, which was established in Entebbe, for you who don't know, Entebbe used to be the Kampala. It was, I think, the capital city. So the National Bank of India started in Entebbe in 1906. Shortly afterwards, 1912, Standard Bank from South Africa, and then Barclays Bank, 1927. The colonial government, to try and bring local content, they introduced the Uganda Credit and Savings Ordinance number 20 of 1950, establishing the Uganda Credit and Savings Bank. This was the first public sector bank in Uganda. This bank was subsequently restructured and dissolved in 1965 under the Uganda Commercial Bank Act 22 of 1965. The Banking Act of 1955 is the first formal piece of legislation enacted to regulate commercial banking operations. So ideally, under this legislation, you'd have expected that we shall deal with the issues of liquidation of banks. That Act of 55 set a minimum capital requirement of 1 million shillings in paid-up capital. I've tried to compute the money equivalent, and since I have BOU here, they will correct me. 1 million shillings in 1955 comes to about 450 million shillings of today. That's what you needed to open a bank. This is important because capitalization is a key factor in licensing of banks, and is also a key causative factor for their liquidation. So that's why I'm highlighting this. That act had a regulator who was in the Bank of Uganda. It was the Register of Companies. And you can imagine a registrar of all companies regulating banks as well. They lacked any prudential regulatory oversight. And so the supervision of banks at that time fell below any standards that we know of today. This void of lack of proper supervision was filled in 1966 when the Bank of Uganda was established as a central bank. The Banking Act of 1969 brought some new changes, including the requirement to incorporate banks locally, and it raised the minimum capital requirement to 20 million shillings. My sister here will tell us how much that is now, but I think it's billions of shillings. And then the Act of 1969 gave the regulatory power to the Minister of Finance. And obviously, this made bank supervision political. It also had its own issues. The Financial Institutions Act of 1993, as we know, it was originally enacted as the Financial Institutions Statute. This replaced the Banking Act of 69. The fear of 93 completely changed the banking sector landscape by giving the licensing and supervisory powers to the Bank of Uganda. And in there, you'll see provisions on non-interference and protection of the independence of the central bank. The fear also introduced a broad definition of the term financial institutions, and now they included other credit institutions and building societies and so on, which were in the money economy. And they also, of course, raised the minimum capital requirements to not less than 500 million for a local bank and 1 billion for foreign banks. So between 93 and 99, getting to the subject at hand, Uganda experienced its first banking crisis. And in response, this was after they closed 4 banks. It was a shock to many of us who were there when the International Credit Bank, Greenland Bank, Cooperative Bank, and Trust Bank were closed in a space of less than 6 years. And eventually, BOU put them under liquidation. The reasons for the collapse of all the banks: severe undercapitalization, weak corporate governance. So this exposed some loopholes in the provisions of the Financial Institutions Act. So that's why government appointed the Justice Ogola Commission of Inquiry into defunct banks under legal notice number 499. In its report, the commission recommended the repeal of the FIA. I think more on the maybe amendment of the FIA because it wasn't repealed, citing liberalization demands. In other words, the economy and everything was going far ahead of the regulation of the banks, and they need to meet the Basel framework, which is the primary global standard set up for primary regulation on banks. And also there were emerging products that were coming up, especially the digital products. Around this time, of course, mobile money and others were beginning to come. And I remember a case I was involved in where we were challenging mobile money, its legality, and the banks were offering escrow accounts to a party they don't regulate to do mobile money. But that's not for today. Anyway, this paved the way for the enactment of the Financial Institutions Act 2024, which codified the fit and proper test for shareholders and directors of financial institutions who had got to be approved by the Bank of Uganda prior to assuming office. Because the crisis, it was understood, occurred because of weaknesses in the persons who took up positions in running a bank. So now they brought a test to check their probity and suitability to become directors or shareholders. The FIA 2004 also increased the minimum capital paid up, and I'm talking about cash, liquid, not just capital in form of the desks and computers, but liquid money that you had to put 200,000 currency points. This was the equivalent of 4 billion shillings. And I have checked in the law, I did not see a differentiation between the minimum capital for local banks and foreign banks. So I assume the 4 billion applied to both banks, but Margaret here will correct if I'm wrong. So despite registering exponential growth after FIA 2004, the banking sector still registered some closures and liquidations after 2004. And the growth was quite impressive because total banking assets were at 3 trillion in 2004, but by 2012 they had more than tripled to quadrupled actually, 14.4 trillion. So it was growing, but at the same time there were issues, systemic issues. So the bubble burst on the 27th of September 2012 when the National Bank of Commerce was closed and liquidated due to what BOU said was severe insolvency and persistent shareholder conflicts. This is a case I was involved in litigation on behalf of the bank, so I can be able to share much more on what actually transpired. There was also a closure of the Global Trust Bank, 25th July 2014, 2 years later. The reason was the same, multi-billion shilling losses, which made it commercially unviable. Then we had the big one, the closure and placement under liquidation of the Crane Bank, 20th October 2016. BOU says severe undercapitalization and systemic corporate governance failures as the reasons for doing that. Just recently, we had a smaller merchant bank, Mercantile Credit Bank, closed on the 18th of June. Again, BOU says critical insolvency, undercapitalization, and poor governance. So you can see these are the main issues. Now, in there, sometime in 2017, a lot of complaints from the public. Auditor General comes in, conducts a special investigation and audit, and issues a report citing several issues. This is a public document. Parliament jumps in. The Committee on Commissions, Statutory Authorities and State Enterprises, COSASE, starts having a public hearing, and people come and pour their hearts out. And it issued this report in 2019, this COSASE. And a lot of the reports were citing abuses of statutory power by Bank of Uganda in closing and liquidating the 7 banks between 1993 and 2016. And among the key abuses alleged against BOU was failure to take a proper inventory of assets and liabilities of the closed bank. So they are saying BOU just came in and closed without, So I will now go to the liquidation processes under the Financial Institutions Act. And for me, my interplay will be between what the law requires when carrying out liquidation of a financial institution vis-a-vis what is implemented. How is the regulator implementing the law? Is there an interplay? Is there a contradiction between these two? That's my main interest. So, as we have seen, there are 2 core reasons for revoking a banking license, which can lead to liquidation of a financial institution, and they are related to severe capital adequacy and poor corporate governance. Very valid reasons. The FIA has a dual model of liquidation, which is either voluntary liquidation or liquidation by BOU. The procedure, I will just run through the procedure of liquidation of a financial institution which is distressed financially under the Act. In section 97.2 and 98.1, if you want to do a voluntary liquidation, you must get permission to close shop from BOU. And by the time you seek the permission, you must have ceased all activities. The only ones that you are allowed to be continuing are the incidental ones which conserve and preserve the assets of the institution. Otherwise, you must have been closed. That is section 98. And then once Bank of Uganda has accepted your request to voluntary liquidation, they will publish, they will make and publish an order for liquidation, which will be published in a newspaper of general circulation. That is section 99, 1 and 2. At that point, the bank will then appoint a liquidator. I have seen cases where the liquidator sometimes is BOU, or sometimes it appoints a third party, an agent, but it's the discretion that they have. So after the appointment, is also published in the local newspapers, and then I believe the first assignment of the liquidator is a submission of a report on assets and liabilities to BOU. This must be done within 5 months from date of appointment. That is section 103. Thereafter, the important assignment is to invite claims from creditors by the liquidator, and then this must be published every week for 4 weeks, inviting people to come. What I have not looked at is how the Depositors Protection Fund comes in here, but I'm sure Margaret can comment on it. But this is the position before that amendment of 2016, bringing Depositors Protection Fund. So receive the claims from the public, and then there is a submission of the creditor claims to the Bank of Uganda, if it's not the liquidator, which has got to be done within 1 month from the invitation of the claims. That is section 102. And then the part of effecting payments to those claimants goes underway in section 105. And this is the point I was saying, that the FIA expressly excludes the mechanism of payment of claims under the Insolvency Act. They have their own. So the first payments are those which are due to the Deposit Protection Fund. The next payment, the liquidator has got to meet their salary allowances. Then the workers of the bank, closed bank, they are paid. This is net. And then I think this includes, if I had a contract for 5 years and the bank closes after a year, I think I get something in advance there. I don't know. Now, the secured creditors must be ranked in pari passu. In other words, they should be paid on equal footing. There is no thing of I came first, I was the first customer of the bank, pay me first. They are paid in pari passu, equal footing. And then for depositors with money in excess of the protected deposit amount, which currently stands at 10 million, those ones are also paid later. So there is some risk of having more than 10 million in your account when there is some issues with the bank. Lastly, the last creditors are also paid in pari passu. I think lastly is if there are any assets, they are shared between the shareholders in accordance with their shareholding. I don't know if we've had any bank which remained with any asset which has been shared. Margaret can tell us, but I've not seen any. That's section 105. And finally, in 1062, a final report by the liquidator is issued to Bank of Uganda. This is a public document. You'll see later in this paper. I am still looking for the first liquidator's report on any bank, but Margaret can tell us. Then thereafter, there will be a release and discharge of the liquidator. So that process must come to an end. Now in Uganda, Afriland First Bank, again a bank I was involved in, became the first commercial bank in Uganda to successfully undergo a voluntary liquidation and exit from the market. It succeeded in May 2022 to do so. The liquidation by the Bank of Uganda, the other mode of liquidation, is provided under section 92 F and 99(1) of the Financial Institutions Act. It basically follows the same procedure I've highlighted below, save for the requirement of obtaining approval from the Bank of Uganda, because BOU does not need consent beyond itself to conduct a liquidation, provided it complies with the requirements under the law. Now, the item number 7 in my paper has pointed out some of the concerns or abuses that the Parliament of Uganda cited Bank of Uganda for. I have checked in all records, again I could be wrong, to see if this COSASE report was ever set aside or expunged from the public records by a court of law. I have not come across any such order. So I'm presenting the abuses alleged against the bank on the presumption that they still form part of the public record. But as soon as I see an order of court quashing this report, I will also ask that this part of my presentation be expunged. But for now, I will submit on it. The first abuse against the Bank of Uganda, before my sister joined that bank, for Tefe Bank, the Bank of Uganda was accused of not, they are saying that the Auditor General was not availed with an audit report, contrary to section 32(3) of the Financial Institutions Act. As you know, the Auditor General audits on behalf of the government and audits all these institutions. They are saying there was no report. So how would you close and no documents relating to the post-closure and management of the bank's assets and liabilities was also availed. So how was TFA closed? That's Parliament talking. International Credit Bank, no inventory report was availed, but rather an inception report for the liquidation by KPMG, the liquidation agent. For those of you who have done projects, you know that an inception report is just a preliminary document before you get into the real work. So for ICB, nothing, just inception report. We are waiting for the proper inventory report. National Bank, this, as I've said, the bank was cited for severe weaknesses, capital adequacy and governance, shareholder disputes. But now when BOU went in, it contravened section 98(3) of the Financial Institutions Act, which mandates it to appoint auditors within, immediately they take over. But now in this case, BOU appointed the auditors 3 weeks after taking over. And yet the purpose of the auditors was to validate and confirm the allegations of inadequacy and so on. But that was done contrary to the law. Has the Bank of Uganda been sanctioned for this? No. So this is how Bank of Uganda closed and sold the bank on the same day. This was a transaction, like I've said, I was involved in. In one moment you receive a notice revoking the license. In another moment, after a few seconds, you receive another notice closing the bank, placing it under receivership. I think the same notice putting it under liquidation. Shortly thereafter, a notice selling it. The deal was already closed. I think this is the fastest sale of a bank in the world. It happened on the 27th of September 2012. But all this happened when there was no inventory report issued by Bank of Uganda to ascertain the value of what was taken over and sold. The shareholders of National Bank are still grumbling. Now, with regard to Greenland, International Credit Bank and Cooperative Bank, again, Bank of Uganda was faulted for the asset movement schedules of the three banks from 117 billion shillings at the time of their respective closures to a paltry 17.9 billion by 2016 June. So the Parliament was saying, how did these assets move from 117 billion to 19.7 billion? What happened to the assets? I think BOU didn't give satisfactory answers. So in conclusion, the interplay between the law governing liquidation of financial institutions and its implementation by Bank of Uganda leaves a lot to be desired. Whereas the FIA 2004, as amended, does not put a specific time limit on the conduct and conclusion of the liquidation process of financial institutions, the failure by Bank of Uganda to conclude any of the liquidations since 1993, in my view, is also an abuse of their supervisory powers. Again, I stand to be corrected if the reports are there now. I will also abandon this. But for now, I say that it's an abuse of the supervisory powers to conduct a liquidation for more than 30 years, even 10 years, even, you know. And this goes against the International Basel Framework on Banking Regulation, which directs that the legal frameworks enable authorities to undertake rapid and effective resolution of the failed banks. Basel acknowledges that prolonged resolution, if you stay in liquidation forever, you erode the asset value of the financial institution and also undermine the public trust in the banking sector. So that is my paper I've given a copy to the Secretariat. I'm sure you can be able to look at it and give feedback. Thank you so much.
Thank you very much for the wonderful presentation. I will ask the classroom to do the needful. Yeah, thank you very much for shedding light. It felt both as a practical class, as a history class, and at one point as bullets to Bank of Uganda. But I am sure that it's for the better of the sector. Now, before the call gets called, we'll just dig right straight into our panel discussion. I will introduce the panel and also the moderator for the panel. I will ask our class to send through the questions in the chat room, and our next moderator will be able to pick them out, both from the presentation and also on the general topic that we're going to discuss on the panel, which is the perspectives on the liquidation of financial institutions. And of course, we'll be picking some of the golden nuggets that have been dropped by Council Fred as far as the same topic is concerned. To discuss that, we'll have Council Justin Semuyaba, who's a senior partner at Semuyaba Iga and Company Advocates. He's a veteran advocate with deep roots in private practice and international legal assistance rosters. He specializes in commercial asset recovery, insolvency litigation, and represents stakeholders navigating corporate litigation and financial sector failures. I would like to also mention that he's an arbitrator and mediator, and is listed as a neutral with World Intellectual Property Organization Arbitration and Mediation Center. He has also appeared as counsel in significant matters before the East African Court of Justice, representing clients in regional, commercial, and constitutional dispute. Key areas of expertise: corporate and commercial law, banking and finance, mergers and acquisition, intellectual property law, and international trade, and of course, ADR. Now, in the presentation of Council Fred, he kept referring to my sister Margaret, and is the next person I would like to introduce. Madame Margaret Kagwa Kasule is the Executive Director, Legal Services, which would substitute to say Head Legal, Bank of Uganda, the regulator. She's the Chief Legal Officer for Uganda Central Bank, responsible for overseeing regulatory compliance, monetary policy, legal responsible for overseeing regulatory compliance, monetary public legal frameworks, and the interventions of the central bank, as were hinted on in the immediate past presentation. She has been with the bank since 2004, so as far as Fred's timelines are concerned, you will know what she's aware of and what she inherited as both responsibilities and mistakes. I need to mention her key expertise in which is banking and finance services, financial regulation, corporate and commercial law, central banking law, financial institution regulatory compliance, and commercial litigation and dispute resolution. That panel, like John the Baptist, I do not have enough anointing to untie their laces, so that's why we have hired the services of Council Andrew Mnanrakamtea, who is a partner at C&LO Advocates, DLA Piper Africa. He's an expert in restructuring and insolvency. He's also, of course, an advocate who advises leading continental funds and standard retail banks on high-value asset tracing, debt recovery litigation, and complex liquidation. He, of course, frequently represents creditors' interests, so he's seated on the other side of the coin in most of the contested insolvency proceedings across the East Africa. He has advised and represented clients in matters involving major commercial banks, financial institutions on loan enforcement and debt recovery. And his key expertise is, of course, in insolvency and business restructuring, debt recovery and restructuring, banking and finance, etc. I could go on and on, but for the benefit of retrieving time, I will invite the moderator to take us through the panel discussion straight away, with our panelists receiving different questions from him to guide the discussion, and thereafter our attendees will be sending through their questions in the chat room or in the Q&A icon, and we will tackle them. So without further ado, Councilman Anura, I decrease that you might increase, sir. You're welcome.
Thank you, Harold. As you introduced us, I wondered why you were doing law. Then I realized you can make any case before any judge. Even a thief might look a saint if you were to represent. But thank you, Harold, for taking us through that. And thank you, Fred, for the insightful discussion on liquidation of financial institutions. Allow me to invite my other panelists, Madam Margaret and Council Samuyava, for this session together. And Fred, yes, as you spoke, my first question was, has BOU done anything right? Or that is something that Margaret should take on, but I felt like I should start in your assessment of the 7 banks and 2 other institutions that they have liquidated. What do you think they've done right?
I think on paper, it is possible to believe that they've done their best, but in reality, I think they have bent to certain directions, because in cases that I have participated in, you have seen situations where a bank is being told that you need to raise your capital up, but at the same time, the regulator invokes some provision there to put a restriction on your activities, trading, so as to raise money. The regulator invokes a provision to put a penalty. You can imagine somebody who is already down trying to raise money, then you put a penalty per day. I think in the case of National Bank, at one time, they had to pay penalty per day of several millions. And I was thinking, then what is the purpose of the regulator? To kill the bank or to help it to survive? So I have found, and for me as a Ugandan, I am very sad that because of the way the law was applied on these banks, we now don't have locally owned banks. I'll tell you that even the so-called local banks you see, if you check their shareholding, it's all foreign. So for me, from a patriotic point of view, forget even legal, I feel that to a big extent, the central bank has done a disservice to this country's economic development, insofar as it has midwifed the death of local banking. And now we have only foreign banks. And as you know, Munanura, when you're dealing with a foreign bank and you want to do some project there in your village, and somebody has to sit in Johannesburg or London to determine whether it's a viable project, it becomes a bit extracted from the reality. So I don't take away the fact that there were issues. I think Ugandans are not very good managers of money. I have no doubt that there were issues with governance and some owners of banks pulling out money, concentrating power into one person. Those issues were there, but for the greater good of the development of the banking industry, I feel Bank of Uganda could have done better. Other countries in East Africa, they have people like us, but their banks are still there. It is because the central bank there is very intentional on ensuring that you promote the the local banking entrepreneurs. So overall, out of 100, I would find it difficult to give the central bank 50 as a score. So I don't know what that is, whether it's a pass or I would find it difficult. But maybe after she speaks, I might increase
You might change your mind.
to 40. I might increase it. Okay.
Yeah. Thank you, Fred. Margaret, it seems that the interplay is now between your power to regulate versus your power to discipline. Fred's concern is that he feels the pinch more on discipline, as in regulate and control. How do you respond to the role that Bank of Uganda has played? I mean, for I think a stellar performance in 30 years, just 9 institutions. I don't think that's a bad run, with the last one being 2016. How do you respond to that? Because you have to control, regulate, but also you have to discipline.
Thank you, Councilman Anura, and thank you, Councilman Wema, for the presentation. I like the way you have pointed out that the COSASE report alleged and that you stand to be corrected in a number of instances, and that you are open to reviewing your score after my submission. But I'm not here to defend the central bank on how it has handled liquidation of closed banks. First of all, I just want to point out that the reason we regulate banks is primarily to protect depositors and the system. Because if the depositors lose confidence in the banking system, they'll stop taking money to the banks. They'll keep it in pots. Investors won't find it in the pots. They can only find it in the banks, where they can borrow it and create more economic activities and then create employment. And then the protection of the system, I don't know where I'm echoing, but the protection of the system. If one bank goes under, it can easily trigger bank runs on other banks. So that's why when a bank has problems, we need to fence it off, exit it from the market before it contaminates others. That is what we call contagion and causes bank runs. So now you are saying, how has the bank exercised the role of disciplining vis-a-vis the need to regulate? I think regulation is intended is a form of control. Unlike other companies, financial institutions are controlled, are regulated for purposes of safeguarding depositor interests. And why does the central bank come in and why does the law impose all these requirements, and why does the Bank of Uganda implement them? Mr. Muwema referred to the 1993 law as opposed to the 2004 law, which we now have kept amending. The 1993 Act was weak. It gave a lot of discretion to the central bank. It was saying, if the bank has a problem, you may. In the 2004 Act, some of those provisions were changed to shall, the central bank shall, meaning that having experienced what we saw in the late 2000s, where Bank of Uganda had a lot of discretion in regard to taking action against Greenland Bank, the Cooperative Bank, ICB, and Greenland Bank, I think ICB and Greenland Bank, we don't want you to have discretion in certain matters. International best practice calls for immediate action, and that the Basel standards call for immediate action. And that's what we see in the 2004 law as amended, it means you must take certain action, even if it's against a local bank or an international bank. Now, he pointed to the issue of local versus international. They are playing in the same market, and you cannot introduce regulatory discrimination. If Bank A is a local bank and you impose certain sanctions, you cannot say, I mean, if it's an international bank and you impose certain sanctions, you can't say that because this one is local, now we won't impose certain sanction. If it's insolvent, we will not take any action against it because, you see, we have patriotic concerns that must be addressed. So the law is applied as is to these banks equally because they are playing in the same market and we don't practice regulatory discrimination. I don't know whether I need to say more about that, but should be clearly stated. But I also wanted to maybe to speak to the issue of whether there have been any successful resolutions, because he said that all these banks, he listed a number of banks, but apparently these are not the only banks that have been resolved. UCB was resolved. It is also a resolution. It was sold to Stanbic. Okay. We had a small bank called Trans-Africa Bank. It was on New Dam House. That bank was closed temporarily, I think for 2 weeks, but afterwards a merger was arranged with Orient Bank, now I&M Bank, and it was a successful merger. Then also we had a bank called Trust Bank. It was on Parliament Avenue for those who are old enough. It went under and was also resolved successfully, and the depositors transferred to a bank then called Gold Trust Bank, now DFCU Bank, and it was successfully resolved. And then also, have we closed any liquidations? Yes, we did close the one of GTB. We closed the one of Cooperative Bank and ICB and TEFE. For the ones that we have not yet closed, and for the ones that are still running, it's because of the litigations. And actually, the litigations account a lot for the lengthy liquidation process, largely because when a bank goes under, most debtors think they are free not to pay the loan. They think that now the bank is closed, its issues are closed, so now I can run away with the money. So we start running after them. They are the cause of the insolvency of the institution. And they are the ones who then go to court to seek temporary injunctions against disposal of their assets. And we get involved in a cat and mouse game in which we are trying to catch the data. The central bank is trying to catch the data, and the data is running around, going to court and stopping us from closing the issues of the bank. I mean, I can stop there for now. Yes, thank you.
Thank you, Madam Kasule. I think perspective is important, and your answer towards the interplay between control and discipline and regulation, which is a very thin aspect, was important. And I liked what you said at the end regarding people who take money from financial institutions. They need to know that they are part of the cause why financial institutions fail. And probably now to Mr. Semuyaba, when you look at the banks that have been liquidated, do you see the Bank of Uganda learning from their past mistakes, or you see them making the same mistakes over and over again with regard to the liquidation of some of those banks?
Thank you. Of course, I've gained a lot of I've gained a lot of knowledge in this sector. Initially, I was just looking at it from the sidelines. You hear a bank has been closed. But now that I got involved in litigation of the Greenland Bank issues, the Kosase report, I've quite gained a lot of insight into this sector. Bank of Uganda, of course, I've heard Margaret talking about successful closures or liquidations which have been completed and mergers. Yes, thank you for those ones. But now, moving forward, I think you will all agree that what prompted the enacting of the 2004 Financial Institutions Act and move away from the 1993 was the closure of Tefe Bank and Greenland Bank. I think the government and the central bank tried to learn. First of all, I think there was no deposit protection fund by then. All of us were actually victims. I remember Easter, first April that year, Easter, we didn't have any money. We were all victims. I think the Bank of Uganda, the government, learned a lesson, and then in 2004, enacted, and they have been amending that law over and over again. They have learned a lesson. But then where I'm seeing they are not learning, Margaret will later on answer us. Like Mr. Mwema started off from the historical perspective of the banking sector, right from Europe and in the colonial days and all that. I don't think closure of the banks is really the solution, because there are so many implications. You've got depositors, you've got creditors, you've got shareholders, you've got so many stakeholders. Where I'm not seeing Bank of Uganda maybe learning a lesson is, can't they introduce some other means of correcting where the bank is making a mistake? I think recently I've seen it being done. Is it Trust Bank? It had to downgrade to an MDI.
Finance Trust.
Finance Trust, exactly. Can't you talk to the bank and say, if you can't meet the standards of the first tier, because I know the banking financial institutions have got tiers. Can't you tell the bank or the financial institution that, please, can't you downgrade to another tier because you cannot manage this tier or something like that? Then you have talked about mergers. Can't you encourage these banks to merge and then beef up their capacity? Because the way I understand it, the regulator, once you fail to maintain the adequate, the minimum capital requirements or other financial thresholds, that's when the Bank of Uganda comes into. So isn't there time to do such a thing? Because the closure causes, I think, problems. So many problems, by the way. Employees, the shareholders have lost their investment. And in most cases, the shareholders, by the way, are not responsible, because for them, they don't know what the management is doing. So you're not going to say the owners of the bank should suffer, because later, and that's what we're having in cases like Greenland Bank. The shareholders are coming back and saying, now we want accountability in your liquidation process. They're stakeholders. Of course, I've seen Bank of Uganda arguing in court that for them, they only deal with depositors. I think it's a completely wrong view, because the Supreme Court of Uganda here, as in the case of Mukwano Enterprises and I'm trying to look through my notes quickly, Rancho Bay, Wambuga and another, the Supreme Court has emphasized the duty of the central bank as a liquidator to many stakeholders. And those many stakeholders include the shareholders. But me, whenever we are discussing these things, even in courts, the bank lawyers are always say, we are protecting depositors, but there are so many other stakeholders, employees, creditors. It's not only depositors. So there's much more lessons to learn for Bank of Uganda as we move forward.
Thank you, Justin, for those reflections, and where you began from, taking the note that 1993 transition, where they liquidated 4 banks. Interesting, the inception of the 1993 Act led to the liquidation of Tefe Bank like immediately, which was interesting to discover. And their transition to the 2004 Act, and your comments on there seems to be greater focus on depositors as opposed to the other stakeholders. I don't know, Margaret, if you want to explain why you focus more on depositors at the point of liquidation before we go into the different transitions. When you determine a troubled institution to either merge, be rehabilitated, acquired, downgrade, because it seems that the public does not know the background story by the time you reach the point of liquidation, the letters, the audits, and etc., etc. But at what point do you determine that? But first, take the first question: why depositors?
Okay, thank you very much. I think the presentation that was made by Mr. Moema spoke to the whether there is a relationship, the interplay between the Insolvency Act and the Financial Institutions Act. That's where I'll start from. Somebody should ask themselves, what were the policy considerations for creating 2 resolution insolvency regimes? The policy consideration for under the insolvency of corporations, of companies, corporates or companies, is concerns itself with the protection of the creditors and the shareholders, and claimants against the. So it is about preservation of rights in insolvency. Of course, there are other factors like maybe corporate rescue, where they want to keep the company running because it employs people and it plays a key role in the economy. The policy issues involved in the financial institution regime, legal regimes, are far higher than that. Why? Because here we are not only concerned about individual creditor rights. We are not concerned only about saving a company. We are talking about the financial system, and which is buttressed by depositor confidence in the system. So if the depositors, so that is why instead of having one category called creditors, because ordinarily you are a creditor to your bank. You are once you put in a deposit, you are a creditor. You don't, they don't say that you own the money as such. It's your money, yes, but you're a creditor. But here the financial institutions law creates 2 categories of creditors. One is called a depositor, and it is purposeful. It is saying that we must give special protection to this category of creditor because he's the foundation for having a banking system. If you cannot have depositor confidence in the banking system, then you don't have one. Secondly, why does the central bank regulate? All other companies have creditors, they have shareholders. No one is regulating them because the shareholders are investing their money, and if they lose it, well, there is an insolvency regime that protects external rights, other stakeholders like employees and creditors, but it is really, it can be isolated from the system, from the economic system. But here, if a bank goes under, there are more issues than that. You'll see bank runs. You'll see banks going down. I don't want to compare any company to a failure, but a live company to a failure. But let's say company A goes under. It doesn't mean that the next company is going to close shop. No. If somebody is selling shoes and it goes under, it is going under. If you're selling plastics or manufacturing plastics and you go under, it doesn't mean that the next company selling plastics is also going to go down. But for a bank, once a bank goes down, and for some of us who are old enough, who were there in the 90s, once a bank goes down, rumors start flying around, and in this era of social media, people quickly transmit messages that this one is almost also going under. In the late 1990s, we saw bank runs. Housing Finance Bank, I stay on Entebbe Road. I just found a very long queue stopping almost at post office. And I said, what's this? It was a run because Greenland was being closed. So you can see it's a system issue. This small bank called Trust Bank that I've talked about was caused because of a bank run. Otherwise, it was a healthy bank. It was well run, well managed, but because of the panic in the market, it got a run, and after the run, it got a liquidity problem. They actually invited the central bank to come and intervene. It wasn't the central bank that took the decision. Otherwise, the central bank was willing to give them liquidity, and indeed, the central bank provided them with liquidity to reassure the public that the bank was okay, but people could not regain confidence. So issues relating to depositor confidence are such sensitive issues, and world over, they are like that. And that is why we even have deposit insurance. Where else, which other company has creditor insurance? You have deposit insurance to still instill confidence that that if the bank goes under, at least you'll immediately get back a certain amount of your money and continue running business. What we need to work as at the central bank and the Deposit Protection Fund is to increase that amount so that you can cover at least 90% of the depositors and continue to reassure the public that their deposits are safe. So yes, I know that most of us lawyers, when we were in law school, we were not taught about financial institution regulation, but those are the policy issues. They are much deeper than what they are system issues. You don't want to take back the entire banking industry because many businesses depend on it, many people depend on it, and if it went under and started dragging others down, you have a systemic issue, which you don't want to have. Now, that is why the depositor has that priority. He even has the extra layer of deposit insurance because he's such a key. Otherwise, courts can even direct that maybe you should have shareholder insurance. Does it make sense? I don't think so. So, yeah. But then, Mr. Semiaba, Council Semiaba spoke to, why doesn't the central bank explore other things like downgrade? We don't want to call it downgrade because when you say downgrade, people feel, the word downgrade.
A good
downgrade it is a transition from one level of one tier. So the banking sector is regulated in 4 tiers. There's tier 1, which is commercial banks. There's tier 2, which is credit institutions. There's a third tier, which is micro deposit taking institutions, and there's that other tier that has money lenders, the 4th tier. And it has circles. Those are the 4 tiers. So if you feel that you cannot meet the capital requirements in one tier, you can transition. We call it transitioning from one tier to the other. We don't call it downgrade. Have we encouraged it? You have seen it happening. Pride, was it Pride Bank? We have seen transitioning from one tier to the other. Pride is now Pride Bank. It was Pride Microfinance. We have also seen Finance Trust Bank transitioning to credit institution. Why? Because they couldn't meet all the requirements of the first tier, and that is preservation of the institution and the economic benefit it gives to society. Have we explored mergers? Yes, we do actually. And on that very point, I want to refer you to section 82. I mean part 9 of the Financial Institutions Act. It has a progressive process for dealing with non-compliant institutions. You can first send them an order to remedy. You issue directives. You require directors and managers of the institution to execute an agreement with the central bank on how they intend to implement the orders given. So it is a progressive process. It is not like the first time you hear that an institution has gone under by a few millions and the central bank moves in to close it. No. There is what we call undercapitalization and significant undercapitalization. When there is undercapitalization, we are taking steps. We are advising them, can you merge? Can you get an institutional investor? Can you do this? Can you be acquired? Only if that fails and it progresses to significant undercapitalization do we lose the discretion that I talked about to do all these other things. But yes, there have been mergers. You know that NCBA is a result of a merger. You know that. And also, I've talked about the merger of Orient Bank and Trans-Africa Bank. And you've heard about the one of the decision of Stan Chart to divest its retail. Now, that is not because they had financial problems, but it is a decision of the management where the shareholders of both institutions, where do they want to be, how do they want to work in the market. Once they get central bank approval, then it works. So the central bank is not there to stifle the business of banking, because that's our bread and butter. For instance, if we close down all the banks, I wouldn't be sitting here. What would I be doing? I don't have a job. We also believe we cannot be the pillar of the economy at the central bank, and then you also are kicking out economic players and those that are mobilizing capital. So I think that is not, please do not misunderstand it. What I also want to tell the lawyers is that when the central bank takes a decision to take any measures against any bank, it is not public information. We don't, for instance, say that, please remember, we get our phones and start tweeting that we have called for capital for any bank X. Do you know what you're doing? That is system damage. That bank can experience a bank run. So you don't, most of the steps that we take are not public information. I can tell you of a bank that came to the central bank because they had a liquidity problem that was initially, let's say, 20 billion. And we were trying to draft agreements and ask them for the securities they'll give us to secure the loan, when they emerged with a request for 49 billion. Before we could process that, the amount increased significantly. That is liquidity support. It is only then that we said, what's wrong with this bank? So it is not, what do they call it? The central bank is not trigger happy. It looks at and makes an assessment. So the bank can come to you with a liquidity. It is only when they ask for a now almost 10 times the amount they asked for in the beginning, in the same period of 1 week, that we said, is it 2 weeks? Then the central bank said, what's wrong with this bank? Who has pulled money out of this bank? And then measures, the meeting started. Of course, not in the public space. So it is not something that the public knows. The central bank doesn't put it on social media to tell everybody that, because you can cause a bank run and a system run. So yes, there are steps taken. It is not public information. If you were to go into the central bank and say, okay, tell us what you say. We even involve other stakeholders. We even go to the Minister of Finance, because he's the Minister of Finance, and we may go for support from there. And if we give any liquidity support, it affects the capital of the bank, and the minister may have to capitalize the bank. So he's also consulted. So it's not a process in which some few central bank staff sit in an office and say, I think we should put a padlock on that, the next bank. Then I think unless there is anything I haven't spoken.
No, thank you, Margaret. Fred, listen to Margaret presents two questions around the reason why depositors are the riding factor. And back to your question, when she talked about the bank runs, the question that came to mind is that when a bank is rumored to, for example, going under, or in the case of National Bank of Commerce, I think, which you were involved in, I think the question to me was, where were the depositors? Because it seems that they're from Margaret's presentation, the very reason why banks survive or remain. So whereas you're increasing, it seems that when a bank has issues, it's just a matter of time, people just start withdrawing their money. So the balance between the confidence of the public in the banking institution and the need to maintain national banks on the market, how would you balance that? How would you suggest that Bank of Uganda deals with that? Because in the case that she gave of Housing Finance Bank, it was a different bank going under, but there you are, immediately they were running and withdrawing money. How do they balance confidence versus your need to have national banks on the market?
Okay, thank you. I think I need to start by correcting some of the impressions that Margaret got. My paper is not premised on the 1993 FIA Act. That was just being used to show where we've come from for historical purposes. It's based on the current law as it is. And then I also need to comment on the issue of the reports. She says they have issued 4 reports of liquidation. But Mnanura, if you go and search now, online or anywhere, and look for these reports, you don't get them. So I don't know whether my search engine has issues, but I would request Margaret for the Bank of Uganda to upload these reports for the public to see what happened, because regulation of banks is a public affair, and so if there is a report, it should be given. And also, I need to say that the reason for litigation as a a ground for not issuing a report for 20 years or, is not strong enough, because this is a legal obligation, a statutory duty. The central bank can issue an interim report and then say, we're still chasing some 3 debtors in Kasese and where we shall give you a final report. But not to have the report completely creates an issue. Now, if the central bank is very interested in boosting the confidence of the public in what it is doing, it must also be ready to comply with the law. Because it's not enough for a regulator to cite the regulated as being non-compliant with the law when the regulator themselves they don't care about complying with the law. The issues which were raised in the Kosase report, the issues which are raised in a lot of these litigations, speak to an abuse of power, allowing of political interference in their decisions and so on. So if the central bank is worried about what the public thinks, they need to shape up these depositors and so on. You know that we have more mobile money bank accounts than accounts in the bank. And why is that so? Maybe it's because of some of these image issues that the regulator needs to boost confidence in the public. Okay, so for me, my comment on the run by the depositors, running on the depositors, is an important one. But Mr. Semiyaba raised something which is which I think is being underestimated, because Margaret was saying that depositors are the foundation of the bank, which is true until you look at the Financial Institutions Act and see how a bank is born. It starts with applying for a license. Who is this person they are talking to apply for a license? It's you and me, the private investor who has money to invest and then give birth to this bank so that the public can now come. Now, for example, in the case of National Bank, the central bank forced the bank to do a call on capital to raise 7 billion shillings. I think the bank was given like a week to raise 7 billion shillings to put in the capital. So you can imagine at that time that was about $2.5–3 million. It was raised in 7 days on the request of the central bank. Now, without any consideration of the investment done, within a month, even less than a month, the money got drained because, like I told you, the central bank kept on putting penalties. You've told me to invest money, but you're tying my hands. You're not allowing me to issue this trade, basically. So how am I supposed to build the business? And so the 7 million was put there, and it was being depreciated by the actions of the central bank, which is why I was posing the question: what is your role? Is your role to kill the local institution or to help it? In the case of NCB, it looked like they were not interested in protecting. I don't know whether it was political or whatever. So for me, banking begins with the investor, because it's the one who risks their money to put up the institution. And once the investor has put their money, you now go to the second level, which is very important, the public. Because an investor will put $1 million, 10 billion shillings, so that the public can utilize the service. That's basically the financial system. So I think that the central bank needs to encourage investment in the sector. They need to be more considerate as well to these investors. And also, my other point, of course, Margaret did not answer to the other issues I was raising. I was hoping she would comment on this issue of why we don't have local banks, locally owned banks here. That's a very big issue. Even Somalia has a locally owned bank. Uganda in this region, we're the only ones. Congo has, you know. All our local banks were killed. Now, I have clients who are, local clients who are in coffee, for example. Munara, you cannot believe it. These guys will get an order for $500,000 to export coffee to Algeria. When they take the documents to these banks, which are all international, they don't give them money. They'll say, no, you don't, we cannot. So, but we have here foreign coffee buyers who are instantly given money to export. Now, if the central bank is supposed to promote economic development, you have a sector like coffee where most locals are participating and they cannot access finance. How are you helping? So me, I thought that as we were ensuring prudential regulation and the balancing of depositors' interests, we also need to look at the interests of the economy. Because where will the local man go? Okay? The reason why you see many Indians here succeed, and somebody comes within 1 year, he has built a mall. They have Indian banks here. They will go to Baroda easily, they will go to, but me and you, we don't have very easily a bank we can go to. So for me, that's a big issue, and I feel that as a regulator, they need to have a deliberate policy of promoting local content, the way you have it in the oil and gas sector and all these sectors. Here we also need to have it. I think we've learned our lessons, and let the central bank be an example of compliance with the law before it asks others to comply with the law. That will also boost the public confidence that she has rightly talked about. Part of the loss of public confidence in the banking sector and why people put money on mobile money wallets and in all these other places is partly because of these issues of how central bank handled these closures. And then what is the last thing here that she talked about? Yes, and she was talking about the Basel standards call for immediate action and so on. I did quote it in my paper, and I said the Basel International Standard, which is binding on the central bank, says that in matters of litigation, of liquidation, there is a need for quick resolution of the matter, because if you don't resolve the matter quickly, you're also going to drench away the public confidence. The case Mr. Samiyaba is talking about of these shareholders still suing BOU and on, these are part of the public. These shareholders are not from Mars. They are also part of the public. They have children, they have wives, they have relatives. They converse about it. And what are they saying? They're saying, we lost this because of BOU. So it also affects how people view this whole thing of banking. So for me, I feel very, very strongly that there is an opportunity to clean up on the part of the regulator, because they have taken a lot of stick, but then they appear not to be bothered. That's why maybe they have never issued even these reports, because it would be very interesting to know what did they find and so on. And
Thank you. I'm getting to just shortly. I think what Fred said, two aspects that seem to be extremely interesting is that the specialized areas, not just banking, if we were to look at it in terms of legal services, look at it in terms of medical services or accounting, the regulators actually crack down on rogue entities, not necessarily because they don't want to boost the economy, but the bad elements would ultimately affect the greater practice of those specialized areas. I don't know if you'd agree with me in that regard?
Yes, cracking the whip is very, very important in streamlining and ensuring the growth of any sector. But if you crack the whip illegally or without compliance with the law, it's like washing a shirt and then you put it in the dirt. So that's all I'm saying. It's extremely important to have the prudential regulation, which is strict for banks. Nobody can talk against that. But if you have selective application of the law, or you violate it freely, and it becomes a problem also to promote compliance and even the way you're viewed by the public. For me, that is the key thing. Sitting here where I am, that is a problem. And public confidence cuts across. It is not just when there is a run-in on a bank. It is also when the regulator is not impartial and, above board. That causes issues as well. And unfortunately, that's where apparently we appear to be.
Justin, you had a comment. Let me take the
just to wind up where Mr. Mwema had reached before we forget. Like we have said, the banks always, the first word they will tell you, for us, we mind about protection of depositors. But we have said, but there are other stakeholders, like Mr. Mwema has said. Who starts the bank? The shareholder invests. Now, the way I look at it currently, and I'll start to be corrected, but I think I'm right, that now the capital minimum requirement was raised from 25 billion to 150 billion. Somebody gets 150 billion, invests it. And you're not going to tell me that you'll only look at the depositor who comes later and you forget about the rights of the investor. Now, currently in the litigation sector about liquidation of banks, most of the cases you have in the court or that have gone through the court are the shareholders. Sudiro Pareria, Mera Investment versus BOU, shareholders. Humphrey and Bank of Uganda, shareholders. Kawesa Suleimani and others versus Bank. The shareholders have now come up to sue. And why are they suing? They are now trying to check the transparency of the process, the fiduciary obligations that the liquidator, that the central bank has towards the stakeholders other than the depositors. Initially, I think before the constitutional case of Sajabi, if you bother to go and look for it, constitutional petition number 40 of 2019, the Financial Institutions Act had section 118 and 124, which was giving it a shield against being sued for this liquidation process. But the Constitutional Court struck down that provision and said, Bank of Uganda is not immune, it's not above the law. It doesn't have statutory immunity. Giving it statutory immunity was declared to be unconstitutional. In the words of Honorable Justice Barishaki, who was a member of the Constitutional Court panel, he said, no one, not even Bank of Uganda, can be shielded from being answerable to the dictates of justice. Section 118 and 124 of the Financial Institutions Act gave unjustified and arbitrary protection of Bank of Uganda, which is contrary to Article 21(1). Now, of course, the litigators should know that Bank of Uganda immunity in this process is no longer there. It was crushed. So, stakeholders have a right now to come and audit, check the process. How is the liquidation going on? Like Mr. Mwema said, Madam Margaret will help us here. Has Bank of Uganda published any report? It's not there. how are they're handling many liquidations, but they are not. I think that one should come to the public. Now, every one of us will know that the COSASE report triggered a lot of people to come back and to look into how Bank of Uganda was running its affairs. And to say the least, I think it opened a lot of fiduciary issues. But now the next question, has Bank of Uganda implemented the recommendations of the COSASE report? To date, the answer is no.
Thank you, Justin. And probably both you and Fred raised an interesting point, which seems to be an interplay now between the Insolvency Act and the FIA, because in both acts, shareholders are the last of the lot when it comes to being looked into in liquidations. And I think that's one interplay I found now, because shareholders don't play in the lot. Even shareholder loans are down in the pecking order. I know because companies are a little different, and I think that's what Margaret was saying. Companies are a little different because then employees come in the preferential dates, creditors, sorry, as opposed to shareholders. So it seems to be that both acts recognize certain order in terms of creditors, and in both settings, shareholders are within the last. Wouldn't you agree, Fred?
Yeah,
before Margaret comes in with an avalanche of answers that would like to. Yeah.
Shareholders are the last, and that underscores the point that the shareholders bear the brunt, the shareholders take the biggest risk.
Yeah.
Because Margaret will come and say the risk to the depositor and this one who, but the first risk and biggest risk is who? The shareholder.
So as a shareholder, the risk is that you will likely lose your money.
Yes, so I mean, because they are an investor and, well, they also take the dividends. If it's a good day,
yeah,
they take the dividends. If it's a bad day.
Which depositors don't share in.
Which depositors don't share in. So,
yeah.
So I think in terms of the discussion for the day, very important to agree with Margaret that because of the uniqueness and sensitivity of the banking sector, we need to have and continue to maintain the special regulation, and the liquidations for banks have to be handled separately.
Yes.
And so at least that's understood. You can't put it in the Kayola, the general things with other companies. So that is well taken. But for me, I am still encouraging BOU to do its part. I think it's one of the good performing central banks in Africa. I'm told our currency was the strongest. Was it last year? The shilling, despite the abuses. You can imagine if they are compliant, we shall be the best in the world. So overall, I think from us, it's words of encouragement to the regulator. Please do your part. We are behind you, but as a regulator, you must get feedback. If we have issues, we must tell you. That's how you improve.
Yeah.
So that we can build our country. Thank you.
I don't know where you want to start, Margaret, but yeah.
Thank you, and thank you, Council Semiyaba and Mr. Mwema. I'm going to start with encouragement. I think the key issue here seems to be, okay, I've pointed out that when you're intervening a bank, this cannot be a public affair for social media to interrogate, but that after the event, where is the transparency? Right now, if you check our website, we are publishing the progress on the liquidation of banks. Please go to the Bank of Uganda website. We have been publishing the liquidation. So we have improved for purposes of giving information to the public. We thought that maybe because people don't know what is going on, that's why they keep thinking that the assets are being taken over by the staff of the central bank. So I think that is a journey. I think that, let me leave it at that. And we think it will further boost confidence in the sector. Now, Mr. Mwema, unfortunately, he's not here, but I wanted him to hear this. But I think this is one thing that I don't want the lawyers not to know. And every time I'm given an opportunity, I put it to them so that when they are interpreting the law, they are taking into account this factor. The capital requirements, the minimum capital requirements, the minimum capital that any investor should bring in the banking industry is to open a bank is 150 billion. That is very true. And after we have given you a license and vetted you as the central bank, how much do you collect in deposits? Trillions. If we are talking about trillions and 150 billion, who is the biggest stakeholder in that institution? This is simple logic. 150 billion vis-a-vis trillions. In that institution, who is the biggest stakeholder? It is the depositor. And if you invest that money, those trillions, in a manner that puts those deposits at risk, how can you be saying that, please think about my 150 billion? I want you to put me at par with the owners of the trillions. And those deposits, and I was talking to the judges recently, I said, by the way, those deposits belong to you and me. So don't look at it as the central bank, because the central bank has also banked in those banks. So when you're looking at stakeholders, you first look at the owner of the bank. And that owner of those trillions does not participate in the decisions on how to invest that money. The shareholder who has only 150 billion is the one who is taking decisions about trillions. Now, when you say that the person safeguarding the interest of 1 trillion is not thinking about this 150 billion, you know, that is why I said that I think that is one thing that we are yet to do in our law school. That should be looked into. 150 billion, trillions. Who is the owner of the bank? If, for instance, in your doing your business, you made losses of 150 billion, who is the owner of the money remaining in the bank? Is it you, the shareholder, who is managing it? You want your interests protected, the 150 billion, against the 150 billion. And whenever I'm listening to that, I just say, well, we need a bit of whatever. So
I think we are saying protect both.
No, what happens
Protect both.
Is that because you're trying to protect the system, if a bank that is big enough, which is systemically important, and I'm going to mention a bank that caused a lot of issues. Crane Bank was a domestic systemically important bank. If you're talking a bank that's systemic, and you find that they have lost more than that 150 billion, supposing they've lost 500 billion, do you know that the taxpayer, your money, my money, still you, the depositor, comes in to save the depositor? That's what happens. So when you say that the shareholder should be somewhere being considered first or at par, or somewhere, you know, there is something that we are missing here. The shareholder sits at the bottom. The reason they sit at the bottom is that because they bring in capital, the deposits are multiplications of that by billions. If they lend it to their relatives, if they lend it to without security, if they defraud the bank and ship out the money, the depositor cries. Why? He's not participating in the decision of shipping out the money. He's depending on the central bank to safeguard his deposit. Meanwhile, the shareholder is doing whatever they want to do. So please, understand this from that perspective, it is very important. The reason that depositor sits at the top and is even insured, it's because of that. Because he's the ultimately, when losses are too many, they erode the capital, and the interest remaining in the bank must be safeguarded for the depositor. That's it. Then the second issue is they talked about why don't we preserve local banks instead of killing them? Now, the key issue that has brought down most of our banks is poor corporate governance, characterized by insider abuse, characterized by poor internal controls because they are violated by the owners and managers, the insiders, not the depositors, not the central bank, not the regulator, the shareholders and the managers, the ones that want to be at par with the depositors. They are those poor internal controls. Now, when you have seen how we Ugandans, the way we behave, I think we like to we move into a bank and we think it's our family business or something like that, and there are all these abuses. But most of these banks, all of them that have gone under, there was an issue of poor corporate governance, and it stemmed from the conduct of our local owners and local managers. So we happen to be in that situation. Of course, even me, I would really want maybe Mr. Mwema to start a bank and run it very well. If he's vetted by the central bank properly with a good number of financiers, that's good, but they must comply with whatever. And then when you say the central bank is not complying with the law when the shareholders are complying, by the time I move in, you are not complying. You have created a lot of complexity. When you say the liquidation process is delayed, when we take over these banks, we take over a litigation portfolio that with debtors fighting against the bank. Now we sit in the shoes of the bank, that bank as the Bank of Uganda, and we start now dealing with those debtors, and the debtors are also fighting. Secondly, if you have a high non-performing asset portfolio yourself, who gave it out and did the appraisal, and it's passed on to the central bank, and you say, well, I had NPS or a bad book worth 500 billion. Why is the central bank selling it at 100 billion? Why didn't you sell it at 500 billion and you save your bank? Well, you also, now you are busy demanding that the central bank should be selling your portfolio at 450 billion. You failed to sell it at 450 billion, and you forced me to walk in and close the bank, something that we consider so painful because many employees lose their jobs, and we see them losing their jobs, and the public panics. So before this criticism goes to the public, whatever, I think the conduct of the shareholders and our local managers should improve, because for you to fail to collect an asset, a non-performing portfolio, and it grows and grows and grows, then as the day the central bank moves in, you say, why are you delaying with liquidation? Why are you not getting a lot of money from my whatever? Mr. Mwema referred to the portfolio of ICB, Cooperative Bank, Greenland Bank, which we combined and sold. I just want to give you information. Whereas the value given to that portfolio was that, apparently most of that was interest. A big chunk of that was interest. From debtors that had defaulted for over a period of 7 years, who we had been chasing, somebody came and offered us 35% for the portfolio that we had been chasing, and collection was next to zero, yet the administrative costs of maintaining a team to collect were becoming high. When a portfolio say, let's say it is for 40 billion is of non-performing assets is being collected, and you find that in a month or 2 or 6 months you're only collecting 1 billion, then the costs of collection start looking like you are just paying salaries for the administrative costs for whatever. So you're selling it even at 35%, so that you get money now, which you will not get, which you will probably not collect, makes sense. So you said that, COSASE said that was an undervalue. Depends on how they looked at from their perspective, yes. That's their perspective, but there is this perspective that I'm talking about, that I've been collecting money. We have a portfolio of a closed bank, which we had put under management, and the manager told us that they can spend 4 months without collecting. They gave it back to us to decide how to deal with it. If somebody gives me 20% or 30%, somebody will come and say, that's an undervalue because it was at 10 billion. How come you got only 2 billion? Wait a minute. I wasn't collecting anything. So it makes sense for me to get the 2 billion, pay creditors, pay whoever I have to pay, and move on. So that's another thing. So they said, so I've addressed the issue of depositor versus credit shareholder. Then also about local banks, I've also talked about it. And then I've also talked about the transparency. I said that one can be done. Then I want to talk about the immunity of central bankers. Now, the immunity of the central bankers is on the premise that they are acting in good faith. I cannot sell properties of a closed bank to myself and I say I have immunity. I must demonstrate good faith. So the question should be, can the central bank demonstrate good faith? I've told you that in that other portfolio that had remained uncollected for a period of 7 years, where somebody offered us 35% of the face value, that was an act of good faith. You'd have to demonstrate that there was bad faith for the central bank to say that, yes, there was a problem. Then also they talked about the COSASE. How far have we gone in implementing the COSASE recommendation? I think COSASE called a lot for transparency, because some of the things that were being explained by the central bankers, they were being explained from the memory of the officers. And the question was that, but show us the record that shows that that was your thinking at the time when you took a decision. For now, all meetings, whether short or whatever, are minuted. I mean, we never used to minute short meetings, whatever, but now they are minuted so that the rationale for taking certain decisions is the Auditor General can always see it. And like I've pointed out, with regard to progress of liquidations, go to the BOE website. The liquidation is actually under the Legal Services Directorate now. It is now on the website, and you can get the information from there. I don't know what I haven't talked about, but with regard to compliance, the central bank is largely compliant. What seems to be like non-compliance is because these things are not in the public domain. So they are interpreted in social media and maybe in speculative things. When COSASE tried to, because there was a speculation that assets of closed banks were being sold and bought by staff, and a full-scale investigation was conducted in land office and everywhere, no central banker was found with any asset of a closed bank or even having touched it. So whether retired or not retired. So that some of these things are speculative. But of course, compliance, yes, we are doing our very best, But my only emphasis before I leave the mic is that the depositor will continue to be paramount. The reasons I've given, 150 billion compared to trillions. When you make a loss of 500 billion, you don't have an interest in that institution. The institution actually belongs to the depositors. Thank you.
Thank you.
Before she leaves, Margaret, the issue of the selling of the assets of Greenland, International Credit Bank and BOU at 19 billion. The issue for Parliament was that you did not avail the reports for these assets that you okay, according to them, you undersold. Just even the reports of the assets to say there was this property, that, this is how I come to 19 billion from 171. That wasn't given. And because of that, it was not possible to validate the basis on which you moved from 177 to 19. Not that what you're saying is not correct, but why wouldn't you then give that decision? Because if somebody gave you 35%, it means you had the asset schedule. So why wouldn't you give it to Parliament? That was the problem.
Thank you, Fred, for the comment. I think while you were out, Margaret mentioned that a lot of those things now on their website, on their own website. But we'll take a few questions. Let's take a few questions from the what Harold called the classroom. I'll borrow your diction, the classroom. And probably this is for Margaret. There are instances in which, this is Collins to Mukunde, there are instances in which BOU has appointed an external rescue practitioner with regards to banks. I don't know if it, I guess if I was in court, I would say that's a yes or no question, but I don't know, Margaret, if that. Then the second one really is from Angelina Namakula, who really says that it's a comment and saying that in her view, the lessons from the findings of Parliament and court are A, and I think Margaret mentioned these, documentation of the process within BOU, and you talked about minutes, etc., and B, once a decision is taken, clear communication with stakeholders. I think that's just a comment, and allow me pick up Collins has a question again. The COSASA report pointed out that 6 months is too short for statutory management. Has the law revised this time limit in order to encourage more rescue-oriented mechanism? That's another question for you. And I think the last question is, oh, a couple more have come in. Samuel is saying that I've experienced okay, that's with regard to connectivity, but he said money lending and mobile money entities occupy certain space in the financial life of the country. The former are known for their aggressive approach. The latter are popular for their accessibility and functionality. As an example, from my mobile phone, I can send money to many destinations around the world involving foreign exchange transactions. So do money lending and mobile money entities in any way come under Schedule 2 of the FIA? Are they in any way under any central bank or affiliates oversight? Then let's take these last two questions. Bazirenge de Muhammad says, what happens to the mortgage that continues to be registered in the name of the liquidated bank even after the closure of the office of the liquidator? Yes, that's one question. It came twice. So I think the ball goes to you, Madam Kasule. Just to recap the questions, one is external rescue practitioners. The second is, has the length of statutory management been increased? Regulation of money lending and mobile money entities, and what happens to mortgaged land after you close the office of the liquidator?
Thank you. I hope I have picked the questions right. I'll answer the first question on are there any external practitioners that are appointed to support the liquidation process? Yes, they are. Right now, it's largely the litigation of the matters, because it is very difficult for the central bank to build capacity in a short time to take over 100 cases or 200 cases against a closed institution after it has been closed. So the most practical thing to do is to get the support of external, to negotiate with external practitioners to do that. Before I answer the next questions, there's something I didn't answer that Mr. Mwema raised, that people are running to mobile money accounts because of the central bank's ineptness in managing things in the finance. First of all, mobile money is part of the payment system, so it's part of the financial sector. Secondly, it is regulated by the central bank under the National Payment Systems Act. And how did it move into the market in Uganda? First of all, when mobile money first came into Uganda, we didn't have a regulatory regime for it. And so we said they should enroll as financial institutions. But they said, wait a minute, central bank, this is not really about, although we are taking money, it's not really banking as such, because we are just moving it. Then we said, but we don't have a regime for regulating it. Then finally we said we could innovate administratively around it. We said as long as they can assure us that that money moving around is reflected in an escrow account in a bank, then we can give them letters of no objection, and then they started operating. And one of the things that we were driving at is that if mobile money can get more people into the financial sector and increase access to financial services, as he has rightly pointed out, then so be it. It is an easier way to open an account, manage people's money. Even somebody with little money can keep it on their account. As opposed to saying that people's increased use of mobile money is a negative for Bank of Uganda. Actually, it is one of the financial inclusion initiatives driven by Bank of Uganda and the sector players. And so it's part of our financial inclusion program to bring more people into the financial sector and to increase access to financial services for those people who cannot transact with the commercial banks, that do not want to set up in I don't know where your village is, Mr. Mwema. They may not want to go there, but mobile money can we reach
Mr. Mwema's village is in the USA.
So yes, no. For mobile money, that one is kudos to the central bank. So that is not something. Now, then you said somebody wanted to know about, Angelina said, have you learned anything? Yes, of course we have. We have learned not only from COSASE, but from the resultant experience that has happened in the courts, and of course the law is being strengthened to avoid some of those pitfalls. And of course, like the practices, even the processes, even inside the bank have improved, so that there is a reference point when the Auditor General comes, says, did you have this process? Yes. Did you adhere to it? Yes, we did. So there has been improvement. Then somebody else wanted to know, isn't 6 months a short time for statutory management? I would say yes and no. You see, during the period of statutory management, the central bank moves into the bank and takes over its operation as if it's the manager of the bank itself. Now, you should understand that that means that the central bank workforce is now diverted from its core mandate of running the central bank and its operations, and is now running the institution. And the longer you stay there, the more you may be committing taxpayers, because you may, when people keep walking in, you must pay their deposits, whether you have liquidity problem, the bank has liquidity problems or what. You don't want to, because you are, the central bank is sitting there, so how do you say we don't have money to pay you? You can't. So it is better to shorten the period and find a buyer as soon as possible, or somebody. I know either you close the institution or you get somebody to take over. And this takes me to the point that Mr. Mwema raised, that many times the banks would be taken over and tomorrow or will seem to have a buyer to take over the operation. That is prudent action. Prudent. The shareholder, I mean the depositor, can continue their business. If you're running a shop, you're capital shoppers, do you want to have to wait for 4 months as the auditor conducts an inventory before you can access your deposit? The answer is no. So what normally happens is that you get the deposits. They are known. The sheet is there. Maybe the deposits are 40 billion. And you get assets, first liquid assets. For instance, if there is cash, you get the cash to match the deposit. Then if there are securities, you get the securities to match the deposit. You first park the depositor somewhere, because you don't want to close capital shoppers, you don't want to close Mr. Mwema's business, you don't want to close Bata because the bank has closed. So you first move that. And there the valuation, cash, you say, why didn't you value the cash? What am I valuing about cash, which are matching with the deposit liability? That why didn't you value the government treasury bonds? The value of the treasury bonds is known. So I'm matching them with the depositor, so that I park the depositor before I start this war with the creditors and the shareholders, the one that people have been so passionate about. But the depositor must first sail off, and normally they go with the most liquid assets. When you're matching their deposit liability, they go with the mostly. So what you people say that this bank has benefited from whatever, it is just that DFCU has taken over these deposits with this cash, with matching cash, with matching securities, with matching other assets to try and settle that depositor. What you're talking about, there's no valuation of cash that I know of. You are doing that. And that's why I said that it's because the process is not really public. That's when people start saying the assets were undervalued. But there has to be a way of closing the bank. Now I'm going to talk about DFCU and Crane Bank. What DFCU took was largely the liquid assets that were available, and for these other assets, they were taken at a discount. You cannot ask me to take non-performing loans at par. And all of us know it. Even all of us here, as we know that non-performing loans can never be taken at par. They will be taken at a discount. And that's because once you have, what is it called, the liquid assets, that is the cash and the bonds, they will tell you that, but you're giving me deposits of 40 billion, and these liquid assets you're giving me are of 30 billion. So unless I leave some depositors out, and they stay there in the cold, you must give me matching assets. That's when you discount whatever is remaining. You create a discount on these other ones, and that is, and so that you bridge the gap in the what is it called? Okay, I'm not an accountant, but that you have to plug the gap, and it must be closed immediately, not after 5 months of the audit when the inventory report comes in. And that's what maybe is not found not palatable. but that's what it is. And also, I want people to upload the central bank. Since I joined the central bank, and it's only recently in Mercantile Credit Bank, depositors have been paid and in full. And that is a very big plus. All of you in those banks, you have received your deposits. And when we had all these court cases and all these things, that's when we started avoiding certain resolution methods that would ensure that. That's why you now have Mercantile Credit Bank depositors. They've only received 60% of their deposit, and I find that so painful. But it's because of the beating of the central bank that why are you paying, why are you doing all these things? I mean, it minimizes resolution options that would make you achieve optimal results for the depositors. So yeah, that's what it is. The central bank has been paying depositors, and the depositors are happy. The shareholders are angry. That's understood. and for the central bank, we have chosen who we should fight with. Can you imagine a situation where the owners of trillions are fighting and the shareholders of 150 billion are the happiest? They are buying Mercedes Benzes where the shareholders are on, the deposit. That person in Owino market selling beans is the one crying. That won't happen, even with too much beating. Then coming with mortgages.
Maybe before she moves. So the shareholders and depositors, who is the chicken and who is the egg?
I have given an explanation. I've told you the shareholders is required to bring 150 billion into the bank before we can, and he's vetted before we give him a license. Along the way, he collects billions. If he makes losses of, say, 200 billion, that means he doesn't have a financial interest in that bank. He is the one who has been controlling it and has lost 200 billion. So what is he talking about that the central bank is coming here and is not protecting me? That is, and all of us here, when I'm saying it, you understand it so well because it's your money. Now, for the mortgage, after the liquidation process, I think that is something that is handled, the process for it. Somebody needs to get in touch with the central bank. And there's something that I thought that I should take back to the governor to mention here by is it Mr. Semiaba, or I have forgotten what it is. I have written
About what?
I said I wanted to go back and speak to the governor about it. Oh, no, there is this one about financing coffee farmers. There is a fund managed in the bank to support those kinds of non-traditional is it not processed coffee, partly processed coffee, non-traditional exports, not raw coffee, but partly processed coffee or something. So there are initiatives by the central bank to encourage access to finance for those ventures that have limited avenues for accessing finance in the banks. There is there are two funds. I've forgotten. There's one called SBRF. Am I mixing them up? And the SCF. Yeah, there are two. Agricultural Credit Facility. Thank you.
But those funds disbursed through the commercial banks. So the problem is, I'm aware of that fund of BOU. The problem is when you go to BOU, they say go to the commercial bank. When you reach the commercial bank, you find a roadblock. I have somebody who had an order of 4 containers to Algeria. The order was there, the guy was ready to issue an LC and everything, but no bank could touch him. And he was a local guy. But the foreigners can easily get financing. So the mainstay of this economy, which is the playground for the locals, is not getting access to financing because of the apparent policies of the central bank in kicking out the locals. And even if they misbehave, if kids misbehave in a school or something, you don't close the school. You put better ways of disciplining them and so on and so
I
forth.
presume that the children that are misbehaving, that school is Uganda, the banks are the students. The students who misbehave are usually kicked out of schools.
Yeah, they could. And here, the students who are misbehaving includes the depositors who don't pay.
The head of
because we have one of the highest default rates.
That's true.
6 out of, I think out of 10 loans in this country, the default rate is like at 50%. So, whereas we glorify the depositors, if I'm an investor in a bank, I'm also suffering because they are not paying and so on. So, but for me, Margaret, before you leave, you see there's an argument you made which is quite attractive. You're saying that the bank is prudent. You go and sit in some boardroom quietly, and then you come and announce that I've taken over the bank and I've already sold it. You see, the law requires you to be transparent. The reason why it's important for you to follow the law, unless you change the law, because the law says when you take over a bank, immediately you must do an audit. What is the purpose of the audit? To establish values. Now for you establish the value before. So in a lot of the litigation, the issues usually are you've sold at under value, you've colluded, that is how you get into those issues. And these are the Basel standards. These are not even just limited to Uganda. So I think as you're going back to the governor, that's one of the things you need to say, you know what, let us go and redirect our mind to what Basel says so that we are compliant. Otherwise, accusations will keep on coming when you do those quick sales, and then people lose out.
Thank you. I think this is a conversation that needs to be taken to a boardroom at Bank of Uganda. I hope that Margaret can facilitate that. I think that the conversation has been insightful, particularly on perspectives, and interesting about how those who represent shareholders or shareholders themselves look at liquidation of banks, primarily different from a depositor, and how Bank of Uganda sits in a very difficult place to regulate, supervise, and discipline these entities. I can appreciate the sentiments from the bar, that is from Mr. Semuyaba and Mr. Mwema, on where Bank of Uganda needs to pull up their socks. And I hope that those who are listening can understand that as Bank of Uganda, they still owe a greater obligation to depositors, of which all of us on this table belong to. So I have no qualms with that at all. But it seems that the takeaway, and one of the questions that seems to be, is how can the insolvency practitioners under the Insolvency Act help Bank of Uganda or participate in some of these spaces? That would be an interesting conversation to have. Mr. Semuyaba, parting shots, then Mrs. Kasule, then Mr. Mwema, and then we'll close for the day.
Well, thank you for giving me the floor to have parting shots. First of all, I would like to thank Uganda Law Society for organizing such trainings. Margaret, even Mr. Mwema, I think we are that generation. In law school, unfortunately, we never met lessons of on financial literacy. It would be good to encourage every lawyer or every legal practitioner to take some time and get yourself financially literate, because you don't know how the role of central bank, you don't know what the commercial bank should do, you don't know the supervisory powers of Bank of Uganda as against the financial institutions. Then you're advising a client in a mortgage, a loan. Then the problems come. You run to commercial court. I can assure you that now commercial court, I think I can say it without hiding, that commercial court has been lobbied by the Bankers Association. For many of us who go there to fight for borrowers, it's a task. It's almost impossible to win banks, because the Bankers Association, which is financially literate, has trained the judges to appreciate the banking and loaning, whatever. Now, you the lawyer, if you sit down and you don't first of all get yourself financially literate on how the financial markets run, I think you are not going to do a very good service to your clients, or advise them, or even litigating in some of these cases. Now, when we have such trainings, you start getting an insight of how the central bank works, how it relates with the commercial banks, even when you have a client as a commercial bank as your client. Now, to listen to hear and tell you that there are some inside decisions that are being taken in the central bank, be careful. As a lawyer, many of the lawyers who have the banks advising them, it's important. But I'll start closing by saying that Madame Margaret has said that, okay, it has been discovered that as a liquidator, Bank of Uganda is not really immune from litigation. They'll protect themselves in the court. They'll come and say, unless you have proof. So for a person going to sue a liquidator under the Financial Institutions Act, I think you have to be careful. And we've done that when we are, because we've done so many litigations against Bank of Uganda or the liquidation. The Financial Institutions Act has got a provision which says that unless you can prove that there is bad faith, fraud, or negligence, then you cannot establish a cause of action. And then we went through a lot of cases which were previously being won by Bank of Uganda in the liquidation process. Then we started learning that under the civil procedure rules, then you are again required even to particularize. So when you go to read, the good thing these days we have only, when you go back to read cases which were lost against the Bank of Uganda in liquidation, they were all being lost on preliminary objections because the practitioners were suing without specifically pleading with particularity in the plaint or the pleadings, bad faith, fraud, and negligence. And then it goes in the civil procedure rules as a requirement that whenever you are raising like misrepresentation, you have to specifically plead it. So again, you have to note that Bank of Uganda as a liquidator has still got that shield. Unless you have specific particulars of where they have done these things, your suit will be thrown out. As I said, trying to get financially literate, I would ask Margaret, as you do your parting shots, to help us tell us, because me, as far as I'm concerned, I've been growing up in this country. I've seen where, okay, after the war, 1986, how things have been evolving. Before the closures of those Greenland Bank and Tefe, I think there was a problem. Our financial markets were not yet, didn't have a lot of institutions around. But right now, as we talk, we have the capital markets as another leg of source of capital of what? You have the depositors fund now. You have now, to improve your management of financial institutions better, can't you advise some of these banks to list in the capital markets? I did some courses in New York Stock Exchange, and they will tell you Africans don't get worried. We also started the capital market under a tree, but it has grown into one of the world's leading capital markets. Now, financial institutions which are in charge of money can also work a lot to go and grow our capital markets. Because capital markets is a good source of money because you get it from the public. In your plans, do you advise these banks that if you have, can't you list on the capital markets so that you get more strength? That's what I would say.
Margaret, over to you, your parting shots.
Thank you. Thank you, Councillor Semiaba, for your contributions, and Councillor Moema, thank you so much. I think I'm supposed to, somebody asked, how can insolvency practitioners help Bank of Uganda? I think it's the other way around. Mr. Semiaba pointed out that none of us in law school were taught financial institution regulation, and so it becomes we learn on the job. And I think it would be helpful if the Bank of Uganda, we have trained the judges and told them about this, but it would be helpful for the Bank of Uganda to maybe Uganda Law Society can introduce as one of its training something to do with financial institution regulation and how it works, so that people understand the intricacies involved and why certain decisions are made the way that they are. So, and I think Bank of Uganda should be willing to, would be willing to help, yes. Then the issue of immunity. Yes, we've trained the judges, so the judges now know. That's why they are saying, oh, for instance, we were advising, during the whatever, we were saying that as you put injunctions to the disposal of defaulters' property, you are making it impossible for the banks to recover your deposits. So it's not really about the central bank making noise or the bank, it's your deposit that you're putting at stake. So when a debtor goes to court, the first question is, did you borrow the money? Yes. How much of it have you paid? You can contest. I think they are encouraging people to contest only the contestable amount, not the money they actually borrowed. If you borrowed 500 billion of depositors' money, and when they try to dispose the asset that was used to secure it, you start making noise and going to get injunctions in court, what are you trying to do? First, deal with the 500 that you are not disputing because you took it. Then you can argue about the interest and penalties and all those other things. And it does make sense to all the people on this call. It makes sense. Why are you refusing to pay money that you actually borrowed? And you are going to court to put an injunction whilst making it impossible to recover mine and all of our deposits. And that's why they are encouraging ADR as much as possible. Mr. Semiaba has spoken to the issue of bad faith. You have to prove bad faith. I've talked to you, I've told you that in the case of the combined portfolio that we sold in 2007, we were fighting to recover even a cent, and the administrative costs were becoming, and eating away everything that is being collected. So selling it even at 35% of the face value made a lot of sense, and it was good faith. Now, on the issue of listing on the capital markets, before I go there, Mr. Semiaba, Mr. Moema, I'll take that thing of the ACF to the governor. And now the issue regarding capital markets, why aren't banks listing on the markets? I think there are requirements for being listed on, for going to the capital markets. there are requirements that, I mean, there are requirements, and of course, it is a decision of the bank to go there. The bank does not try to tell shareholders how they should run the affairs of their institution, because that would be micromanagement. We trust that once classified as fit and proper, the bank should be in position to take the decisions about how to capitalize their banks and to keep sound institutions in the market. Now, what is my take from this? I believe, and I've always observed, that there seems to be lack of information out there on what happens when banks are not doing well, and the expectations cannot match the reality. I've already told you that when a bank is having financial problems or corporate governance problems, we do not go out there to tell everyone that, by the way, do you know that this bank has these issues? And even me, even if I've read a paper here today that this bank has a problem, I cannot even discuss it with my husband, because I don't know whether he will be tempted to tell his sister or his whatever, and then a run is caused by me. So some of those things are not known. And I want to assure you that always efforts are made to resuscitate, to make banks stay in the market. For Council Mwema, he pointed to the issue of NBC Bank. They had shareholder wrangles. At one time, we sat with them on level 7 in Bank of Uganda and had a discussion that they should stop this fighting, because ultimately, if it goes out, it is going to affect confidence in their bank. And we encourage them to bring in an investor. But of course, that is not a discussion that we are having. I want to assure everybody on this call that efforts are always made to keep the bank in the market. Because we can't say we are the pillar of the economy, and at the same time we are taking steps that take away jobs, that take away banking services, that deny, it cannot be that that can't be, unless you think that all those brilliant minds at the central bank that have kept the currency stable for a very long time, when it comes to regulation of banks, they want it to go in the negative. It's just that the information is not shared for people to see the rationale why certain decisions have been taken. But my take from this call is that there is need for further information provision, and I think the practitioners should be given some insights on financial sector regulation, how it works, and how certain decisions are taken. It was there before, when I'd just become the legal counsel, but I think it has been, and I hope that we shall continue it. Maybe the Uganda Law Society should take note. Thank you so much, though, for giving me an opportunity to speak to the issues, and I'm sure that when we leave this call, people are going to be better informed than how they were before. Thank you.
Okay. Again, thank you, Uganda Law Society, for organizing this. But Margaret, as you leave and you circulate my paper to the governor and others, yeah, just know that I was part of the Bank of Uganda community, because my late mom used to work there in the 80s and 90s. And so when I am throwing some barbs, I'm doing so in memory of my late mom, so that where she used to work can be better. Okay, that is one. Number two, the call for practitioners to support the central bank in performing its duties and doing all this. We've already heeded that call. When I heard you speak about mobile money, maybe you've forgotten, I filed a public interest suit, Matthew Kiwunda versus Minister of Finance and Parliament of Uganda, to force them to enact a law to regulate mobile money. I appeared before the Committee on Finance in Parliament to give views on the National Payment Systems Act. So the appeal here is, as legal practitioners, can we support to enrich the jurisprudence and practice in the banking sector by taking up such suits? So eventually, to the credit of Parliament and the Ministry, the matter was settled. That's why you don't have a decision, but if you go online, you'll see the suit. And that's how we got a law to regulate the biggest payment platform in the country. So my appeal to my colleagues, let us be intentional about participating in litigation or actions that help to grow an important sector like the finance sector. It's good to participate in a suit to protect the data or to recover debt, but I think we can do more because the central bank cannot succeed without public support. And then the last thing for me is the issue of accountability on the part of all of us. Like Margaret has said, if you borrowed money, you're accountable, you pay it back. It's as simple as that. In the same way, again, my message to the central bank is be accountable. Be accountable to this very public that you say you are protecting. These depositors want you to comply with the law and the regulation as much as you want them and the regulated to comply. If we can achieve that, even at 50%, then the whole landscape will change and we shall have more and more growth in the sector. And lastly, the issue of the local banks, us having local banks. I think this is something of national policy, basically. We have government intervening, bailing out. I have some clients in the poultry sector and other sectors. They get bailouts from the government. Why? Because the government is looking at the importance of these sectors to the overall, macro situation in the country. We cannot leave this to foreigners. They are not going to grow our country for us. If we are making mistakes and we have bad governance, you whip us until we put it in line. So I would like to hear next time that efforts are being made to ensure that Ugandans participate in the banking sector beyond just being spectators or depositors. We also need to be there so that we can have meaningful participation. Otherwise, thank you so much, and thank you to the audience online for being lively, and I'm happy that you are firing a lot of questions to Margaret, because Margaret was the prize. She's the important one in this one. For us who are just, escort boys. The maids. Yes.
Thank you,
so
Fred.
much.
Once again, thank you to the 106 attendants online. The call has been made for us to share the presentation. So over to you, Harold. I hope you will facilitate that so that people can get the presentations. Regarding local banks, I think what I heard from Margaret is that they're waiting for Fred to put in an application. So go for it, my friend. Let's look for the 150 billion and start a bank. And from what you said, Fred, the final thing that you said that was extremely interesting was we are part of the problem, yet we are the solution. So let's be the solution. Thank you everyone for attending. Over to you, Harold.
Yeah, thank you very much. The moderator and all our panelists, I think they deserve a very thunderous clap for giving us their time, for giving us their expertise, and assisting us through this very heavy topic. I think the most bruised would be the regulator, but I'm sure we've laid bricks in the right direction. So thank you very much for representing the institution that we believe will lead this discussion in the right direction, that the mistakes of the past shall not be repeated, and it's a sector that will grow more and more. I know our time is fast spent, so we're just closing. And the minds of the classroom is that lunch is taking priority over the unsecured creditors. But we close by giving you thanks for, first of all, paying, whether you are here voluntarily or you are here for CLE points by being forced by a managing partner. You learnt a thing or two, and I'm sure that you do not regret the time spent here. We've seen the countless requests to have some of these presentations shared. I think because this is recorded, we would encourage you to type your email addresses, and we'll liaise with the Secretariat to see how these presentations will be shared in the course of the week, and we will liaise with the Secretariat to make sure that is done. Now, there's also a survey that we took yesterday, and it continues to appear on your screen on some of the things that we need to take home as a basis for improvement and better conferences next time. Please make sure that you participate, and even if you have a comment like that on how we can make this better for the next trainings, please type it and do not hesitate to do that. Until next time, we want to thank you and ask you to keep engaging in some, and look out for the Law Society activities on this. We want to thank the Secretariat, Uganda Law Society, and for the benefit of not just jumping out of the boardroom, we will adopt the opening remarks of the Vice President as the closing remarks. And thank you for attending, for God and our country.